Commission or makes a statement before it that is false or misleading, commits an offence and is liable to a fine or a term of imprisonment not exceeding a period of 2 years. You are required to take an oath or affirm that the evidence you shall give shall be truthful. Which one do you elect, oath or affirmation? You have elected to take an oath. May you please follow me as I dictate to you. May you please say aye and state your names in full.
Kishen Chetty. So put it off.
Yeah. Let's repeat that, Mr. Chetty.
I, Kishen Chetty,
Swear that the evidence I shall give
swear that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
And so help me God.
And so help me God.
Thank you so much. I'm handing over to you and the senior counsel to start with the presentation of evidence. Can I check, senior counsel, how many hours do you need to conclude the presentation of evidence?
Chair, always difficult to predict, but I wouldn't expect us to be longer than 2 hours, if that long. As I said, you and the honourable members would have gone through this affidavit. It's lengthy, but it's full of technical, legal.
No, it's fine. If you need 2 hours, let me exercise my benevolence and say that you run until 13 hours. By that time, Mr. Chetty and senior counsel, you must be done with the presentation of evidence.
Thank you, Chair.
Do everything within your abilities to ensure that by that time you are done. Thank you.
Thank you. Thank you.
Let me wish you good luck. Thank you.
Mr. Chetty, you reference a number of cases in your affidavit. There is the Silverton case, which is case number 335/2/20, and then there's also a number of other cases.
Sorry, I don't understand.
Then there are also a number of other cases. Silverton case numbers and Brooklyn case numbers. Now, in our discussion and in my understanding, you had initially been an accused with some 70 other accused, which is some 40 odd natural persons and 30 odd juristic entities, companies, CCs, in case 335. We can call it 335. That case, which is referenced in paragraph 1.1, honourable members, that case was in March 2021. Is 2021? 2020?
2020.
2020.
4th of June, 2020.
4th of June 2020.
Yes, we were arrested.
The case was struck off the roll.
No, it was struck off the roll on the 25th of March, 2021.
Yes, that's the one I'm referring to. March 2021. The case was struck off the roll in terms of section 3423, capital letter C, by the magistrate. Is that correct?
You're correct, Counsel.
And that's what we can call the big case, right?
Yes.
Subsequent to that, there have been several, you were arrested and charged in several other cases, which, as it were, mutates from this big 335 case. Is that right?
Yes, Counsel.
And those are the cases that we see referenced there: Silverton, 143, 145, 142, and Brooklyn, and 147. So those cases, they are taken from the big 335 case. Is that correct?
Yes, Counsel.
And your case is that in itself constitutes an abuse, because 335, in terms of 335, I think we know now from another experience with another witness, when we deal with 342, striking off, that it can be enrolled, but it can only be done if a certificate is issued by, these days, the National Director of Public Prosecutions. And that was not done. Is that right?
Yes, Counsel.
But I think in our discussion, subsequently, you say that 335 has been reinstated.
Yes, Counsel.
Okay. So we also know from our consultation that you have brought an application to have these cases set aside on the basis, amongst other things, of an abuse of the process and unlawful interference in these matters. And that case is still pending in the High Court. Is that right?
Yes, Counsel. We're waiting for a judge to be allocated to the matter.
Yeah. So, and you appreciate and understand. In fact, you to your credit, you pointed out to me that you are not here to debate the merits of these charges against you. The charges in case 335 relate to theft, corruption, money laundering, and quite a number of serious charges. Is that right?
100%, Counsel.
You're not. You're obviously defending these charges, but you're not here to debate the merits of those cases.
No, I'm not.
Your complaint before the committee is you link it to the terms of reference of this honourable committee, and that is interference, unlawful conduct, unethical conduct on the part of the police, and you in particular point fingers at officers Baluchan, Shabalala, Perumal. Are they? Shabalala is a prosecutor, is that right?
Yes, he's a prosecutor in all my cases.
In all your cases?
Yes.
And Perumal and Baluchan are with IDEC?
Yes, with IDEC now, yes.
And Lowe, the other person?
Paul Lowe is an advocate that is at IDEC.
At IDEC.
Under correction, Shabalala's senior.
Okay. And those, you say they're the main actors in the narrative that is in your affidavit?
Yes.
But we also know now, in fact, perhaps tell us about the call you received yesterday from IPID.
Okay, Counsel. I opened a case 12/7/2022 Silverton case in 2022 after I realized that charges were taken off a case that was struck off the roll, 335, and it was duplicated in case 143, 144, 145, all Silverton cases. I then opened the criminal case. It was then taken to Gauteng province. Everything is in my affidavit here, so let me just talk about that case 12 of 7 as you're asking me about the call. I received the call day before yesterday from Mr. Baloy at IPAD because 12 of 7, 2022 is at IPAD's office now. And Mr. Baloy told me that the advocate from the DPP's office, North Gauteng, called him and asked him to come and collect the docket and obtain warning statements from these 3 individuals. Dylan Perumal, Sunil Beluchan, Richard Shabalala. And I then told Mr. Baloy that I will be coming here today and he must please tell me, like last night, if he called him so I can put it on record here because on my affidavit it shows exactly what has happened to this docket since I opened it in 2022 to where it is now. So Mr. Baloy did tell me that he contacted Sunil Beluchan and informed him that he needs to obtain a warning statement, and he couldn't get hold of Dylan Perumal and Richard Tyler Shabalala, reason being that they on leave. So that's where it stands now. But in my affidavit, it stipulates exactly from the time I opened the case, it went up to the DNC's office, up to General Libia's office at the Hawks, and it shows the abuse of power. Everything is in my affidavit. So on the call that I received yesterday, that's it. It's with Mr. Baloy now. The docker is with him.
So that case is also currently pending and being dealt with by IPAD.
Yes, and just to bring it up, explain what it is, that case is what I'm here for on the duplication of charges from the case struck of the roll to the baby cases that was opened. That is based, that is my complaint, that is 12 of 7, 2022.
Yes.
Yes.
Now, what would you want this honourable committee to do or to recommend some remedial action in view of the fact that your complaint against Baluchan, Perumal, Shabalala and Low, those cases are being dealt with by IPAD. You've also complained to some very senior SAPS officers about their conduct, that case is pending, and your High Court application to have these cases set aside, that case is also pending before the High Court.
Council, I would appreciate the committee to see or understand the exact abuse of power. This IDEC officials, the courts, especially Palm Ridge Magistrates Court, Pretoria Magistrates Court, Pretoria High Court, on how these individuals bring cases on the roll as they please and not following the court rules, the uniform court rules of the court. Because I did a lot of background checking as we go through my affidavit. The committee chairperson will see what my allegations are, because I have all the next years of court books. We're appearing in court, but we're not registered on the court books. I have transcripts and so forth. So basically, it is on the abuse of power of these guys. And when I do complain about them, I'm getting arrested, or they're retaliating on me by using state machinery. And I have proof of all of that.
And your status currently is that of an accused in all of these cases, and you autom. Sorry. Sorry, thank you.
Thank you, Chair. I'm sorry to interrupt Mr. Orrington and Mr. Chetty. Chair, I've gone through this affidavit, and I'm very concerned that, well, I'm concerned about the contents thereof, and I'm concerned about why Mr. Chetty is here today. But I'm more concerned about the fact that he's not here with any representation. which is also a concern to me. Advocate Arendse is not his legal representative, he's the evidence leader. So Mr. Chetty is not his client, and he doesn't have to advise him in his best interests. But Mr. Chetty is the accused in a number of very serious matters that are currently on the roll or to be placed on the roll. They're currently in court. And I don't know if his legal representatives in that matter know that he's here. And I don't know if they helped him draft this affidavit. But my major concern is that we operate on a principle of innocence until proven guilty in this country. But he stands an excellent chance today of doing himself a lot of damage in those matters that are on a criminal roll. And that's really something serious that he should think about and we should think about. Because he's just said he's here for 2 matters. Well, that's not really why he's here. Now that he's here, we can ask him about whatever we want. And he's obliged to answer. He may well find himself in a position where he has to incriminate himself. He's not represented. He's got no one to advise him. It's not our job to advise him. So I'm concerned about what we're busy doing here today is, for me, not quite right. But I'm also concerned about his position in terms of his constitutional rights and his right not to incriminate himself. He's not a lawyer. He's a businessman. As he says, not doing business at the moment. So those are my concerns, Chair, and for me, they're serious concerns. Thank you.
Let's see. What is your response to that?
Honourable Chair, as I indicated in some introductory remarks initially, it was Mr. Chetty's father who had lodged a complaint, but it was about the conduct of a curator in a matter. I'm not sure whether it's in relation to one of these criminal matters, but I know they're also facing some charges which the investigating officers say emanate from tax fraud. But subsequently, only last week or the week before, a substantial affidavit was sent to Mr. Romano, which was then passed on to us. And we were required to consult with a witness initially. Advocate Mkhize was going to lead Mr. Chetty's evidence, but you'll recall that on the day, I think it was last week, we either couldn't accommodate him and he's come back. The concerns raised by Honourable Breitenbach are shared by us, and that's why I indicated also at the outset that I will try and make sense of what's in this voluminous affidavit, and I'd also asked what, if anything, this Honourable Committee can do other than what I did, which is to read the affidavit and listen to Mr. Chetty very sympathetically. According to his narrative, he seems to have been badly treated. But again, it's just one side, or one side of a story, and I'm not sure that there's anything we can do about this other than to note his claims, and I suppose significantly the names of Baluchan and Perumal and some of these officers, their names have cropped up in some other matters from other witnesses. So that might indicate some kind of pattern. But the fact that IPID is now investigating the case that he has brought against them, the fact that there is a High Court matter that's pending, and they're waiting the allocation of a judge, where in the correct forum, a judge will, having heard argument from all sides, from both sides, will make a determination whether or not these cases should be dismissed, and the prosecutions not proceed, which I'm not even sure that a judge can do, given that these are all matters that's pending before different courts. So all that I'm saying, it wasn't for us, Honourable Chair, as evidence leaders, to make a call and say, no, we don't think you need to hear this witness or listen to the witness. It's going to be a waste of time. We were asked to consult with him, to interview him, and we are here now today. Other than, in summary, to say, I think the concerns raised by Honourable Breitenbach are valid concerns, and that perhaps the better thing, or the better course to take, is to note what's in his affidavit when the committee comes to its deliberations, and to take serious note of some of these allegations, which some of them are quite hair-raising. These Silverton and Brooklyn cases, they arise from this big 335I case, as he called them, baby cases, and it's been done selectively. But again, it's either for the trial court to make that determination. I don't think we equipped. Maybe Honourable Breitenbach is in a former job, but we're not equipped to, or maybe Mr. Novalo as a practitioner. Thank you, Chair. I'm sorry if I'm not being particularly helpful.
Yeah. No, let's do this now. Okay. Can I hear you?
Thank you, Chair. Yes, Chair, in the defense of senior counsel, he is not known for being a criminal lawyer. His expertise lies elsewhere. I honestly submit, it's my view, that we're about to seriously prejudice Mr. Chetty. Whether he realizes it or not is not really relevant. We're about to do serious damage to whatever case he may have. And I would urge him to not proceed with this. We can take note of this affidavit. There is stuff in here that is concerning, but we can read it. If he opens himself up to questioning, Chair, I foresee serious problems that I'm not entirely sure that I'm comfortable to participate in. Because once he does that, it is our job to question him, and he will really not come out of it well. And it can only prejudice his case. I don't know if his lawyers know that he's here. Certainly if he was my client, he wouldn't be here. And this, the contents of this affidavit, apart from the suggestions that there is foul play with the investigators mentioned, which we already have heard of them and we can take note of and look into, the rest of it is not relevant to this committee's inquiry, in my view. And so we're going to spend a day trawling through, with respect, irrelevant information, not even evidence. And it's the prerogative of a prosecutor. It's not this committee's prerogative. It's not even the court's prerogative. It's the prerogative of a prosecutor to charge people as and how they wish, and to group charges as and how they see fit within the prescripts of the Criminal Procedure Act. It's a very difficult thing for anyone to interfere with, because there's a certain game plan. Of course, every accused is entitled to be charged with everything at the same time, if it happened at the same time and placed under similar circumstances. But if not, no. The prosecutor charges in the fashion that they see fit, and nobody can interfere with their discretion. So this committee certainly can't. We can't help him with that complaint. Richard Shabalala is a prosecutor of many years' experience. Paul Lowe is a prosecutor of some 40 years' experience. They certainly know their way around a criminal court. And I'm sure that they're both watching TV right now, waiting for the questions to come. Because please believe me, they will use it against him. And there's nothing to prevent it being done. I really urge us to reconsider what we're busy with here today. Thank you, Chair.
Can I rotate you, honorable members, and hear?
Thank you so much, Chair. I think what Honorable Bredenbach is raising, Honorable Vessels would have shared it with me yesterday. And unfortunately, the same concerns that he would have raised yesterday, I didn't get an opportunity to look at the affidavit at that time. But I think it's quite concerning, one, when the evidence later says the actual complainant is not the person who's in front of us. Someone else submitted the complaint, but someone else is appearing before us. Maybe the evidence leader would actually explain to us, boss, if I hear this properly. He actually says, I'm not sure the father submitted, something like that. But as I say, he will actually explain further so that for our understanding of what he's saying. Two, Chair, I think it's important. It would have been raised by members on our housekeeping committee meetings that between the evidence leaders, the legal unit of Parliament, and the Secretariat, there must be a way of checking unto the nature of the people who apply to appear before this committee. Because it's quite cumbersome now. If every now and then we are to discuss in this setting, in the presence of the person who would want to come and present to us, in front of South Africa, that no, this person was not supposed to be here. The nature of that which is submitting to us was, it would, in our view, Chair, that they would brief you about the nature of that particular submission. So that you come to the committee and advise the committee better, so that the committee takes a decision whether to invite or not to invite that particular witness. But it's becoming a problem. Now, we agree, Chair, the nature of what is said in the affidavit requires a competent court of law. And it's a detriment, it's a legal detriment to Mr. Chetty himself to come and answer here. And you'll recall, Chair, would have said, in a number of witnesses, they are not at liberty to come and tell us what to ask and not what to ask. But when the evidence leader and Mr. Chetty are starting interacting, there is already a condition that I'm not prepared to answer this matter and this matter, then this matter, because it's in court. Now, consistency compels us to say, we have said to General Patlane, we have said to so-and-so, that they are not going to put forward conditions for us to proceed. Now, part of what we pick up from Mr. Chetty's argument in the affidavit is that there are people who are charged by the state to preside or process his cases, which some he accuses of them having been convicted before, both at IDEC and some having been subjected to an internal DC of SAPS. That's a matter, Chair, that I think if we agree on an approach, just to say from IDEC head and SAPS, give us a status of so-and-so, whether or not they got charged, whether or not they were disciplined, whether or not they were convicted, and all those things. But it still matters that Mr. Chetty and his legal representative must raise in a court of law that the nature of how the state has processed my cases has got these irregularities. So I believe, Chair, and we agree from where we're seated, that it's not only a problem of the committee, it's majorly the problem of Mr. Chetty to come and divulge some of the issues in this particular platform that are still subject of a competent court of law. We'll all agree, Chair, that the rules of the National Assembly do not allow us to get into the merits of issues that are still sub judice. So I think, Chair, we must plead with Mr. Chetty, and I'm worried. This may appear as though that we don't want Mr. Chetty to come and talk to us. We'll recall that this is the second time we're discussing his matter, and I'm asking him to go back and come back and all that. It may appear, Chair, that we don't want Mr. Chetty's testimony and all that. But the major concern is that we are to respect the state process and the judicial process. And we are not willing to be part of ruining his case and his presumption of innocence. So it's us pleading with him that he must reconsider, then we'll take it from there. Thank you very much, Chair.
Honorable Nomvalo.
No, thank you, Chair. Chair, initially when Honorable Breitenbach was raising the matter, I was agreeing with her overwhelmingly. But there's an aspect which I don't agree with. When she wants to project certain people against whom complaints have been laid in this affidavit as a paragon of virtue. He's even citing their experiences and so on. I think that is unfair, and that is being argumentative against the witness before us, because we must be fair to witnesses here. Allow a witness to present, and then when he has presented, you make your arguments. Not to say when a witness has not even opened his mouth, the people that we are complaining about are competent people, they have experience and so on and so forth, as if the witness is hallucinating. That witness is raising these complaints out of frustration. I understand the legal aspects and the legal concerns that Honorable Breitenbach is raising, and I agree with them to say it's going to be prejudicial to the witness when he deals with matters which are before court or which are pending, because even with us, it's going to be difficult to interrogate his testimony, because we will interrogate it with caution. We won't understand to which extent we should go, because we will be trying to save her, and we will be trying to save his right to be innocent before, to be presumed innocent before he's proven guilty. So, but the problem here, Chair, is that our house is not in order. It goes back, and I'm afraid now that witnesses or members of the public largely are going to be on the receiving end of our demise as the committee. But that demise is orchestrated by the legal team. We raised this thing in one of our meetings, Chair, and we asked a question that, what is it that a witness with the evidence leader do during consultation? What are they doing? If here in this committee we deliberate on issues that are supposed to have been dealt with during that consultation, because they have been employed to do exactly that, to say this evidence by its nature does not belong to a committee. Maybe you must submit a written statement, or maybe you must apply to tender this evidence in camera because of its nature. That guidance is supposed to be tendered during that consultative process. But it does not happen. What are they doing? Maybe Advocate Arenzo needs to tell us. What are they doing during consultation? Are they guiding witnesses on legalities or not? Or they just accept, they just say, no, bring everything, we'll just pass it as it is to the ad hoc committee. So I'm very worried, Chair, in as much as I agree with Honorable Breitenbach that now we want to turn away a witness who has come here under an impression that he's going to get an opportunity to explain his side, and who was going to do otherwise if he was properly guided by the evidence leader. So he has been failed by this committee. He has been failed by the evidence leader. And now we want to suffocate him. We want to turn him away. He has compromised all his schedule to come before this committee and argue for his case. When we're here, I understand, members, because we knock off at night here, so we don't get time to read these statements. I've only read it now when I'm here. And I'm getting concerned as I'm here as to what is it that we're expected to do here when a statement from page 1 until the last page talks about cases which are pending before a court of law. So what are we expected to do as members of this committee? So, Chair, I know we're towards the finishing line. We're at the tail end of this process. But our concern remains very high against the evidence leader and his team on how they conduct this work. They are not doing their job during consultation. That is why sometimes we read 180 pages, which is full of irrelevant content. Because during consultation, they must say, no, this one, Advocate Patlane, when he was here, was told by members that, no, these are labor issues. Those are the issues for which he was supposed to get guidance during consultation. To say, no, this one does not fall within the terms of reference. It must not go to the committee. Because he has been employed to do that. So, Chair, unless the witness before us feels strongly that he wants to continue under the guidance that we have given him, or even after the concerns have been raised about the risk he is imposing himself to, we are saying we're of the view that he must submit rather a submitted statement, I mean a written statement. It's unfair to say he must not submit anything at all, because he's complaining about the judiciary here. So when you say the matter is under a competent judiciary, we are already making a judgment that all the complaints he's raising are invalid, because the institution that he complains about cannot help him if he feels that it is compromised. How can you complain to the same judge that you are complaining about, to the same magistrate that you are complaining about? So let the client not be helpless. Let's not make him vulnerable and say, no, go away with this statement, we can't help you. If he continues to feel strongly that even after this he can continue, it's fine, he can continue. But as this committee, we have been honest to him to say this is prejudicial, but if he wants to continue, can continue, Chair. Thank you.
Honorable Breitenbach,
Chair.
do you want to speak?
Oh, yeah, Chair, just on one point, I didn't mention Shabalala and Lowe to suggest that they're untouchable. I mentioned them to suggest that they have a lot of experience and they will be watching this because it's an opportunity they wouldn't let go by. Not any other reason did I mention them. Yeah.
Okay. The EFF?
And Chair, I remain deeply uncomfortable with the process.
Okay,
I'm not sure that I want to participate.
sure.
Thank you, Chair. Hey, it's embarrassing. We are an embarrassment to the people that have elected for us to serve here in Parliament, that we can even sit here and while after a witness is even sworn in, that we raise things that should have been resolved a long time ago. I echo my colleague's point of the issue of resources for this committee. I disagree with him that we must put the blame squarely on the evidence leaders. Literally, we have 3 evidence leaders. If you go to that commission, who's pretty much has the same number of witnesses that we are dealing with, they have like a whole team. Our legal team here, our technical team here, they're not here full-time, Chair. And we've been raising this for a very, very, very long time. We even got a letter, or finally the letter was circulated on why we don't even have a forensic investigator. We are an embarrassment to the people who voted for us. Parliament is an embarrassment not to provide adequate resources. And it's got absolutely nothing to do with the fact that we don't have money to be able to serve South Africans with the dignity and the efficiency that we need. It's just embarrassing. And on the merits of what has been raised here, I think it's highly disingenuous to talk about active cases. Pretty much every single person that has come here, senior officials of SAPS, they have active cases. It's not going to be the first time that we've had witnesses, even in committees, where they say, I can't respond to that because it's in court. So to all of a sudden feel uncomfortable participating because someone can be prejudiced is, I don't even know where we're pulling that from. It is something that goes on here. It's even weaponized in this parliament, even in committees, that we shouldn't ask that question because that question is going to jeopardize the case. We hear that it's a long sing-song story. Mr. Chetty has been here. This is his second time. The first time we even sent him away. The fact of the matter, whether this is related directly to our terms of reference or not, it's a bit late. So unfortunately, we're going to have to take his case. There are matters of SAPS that are involved in here, and we are going to hear because we are the People's Parliament, and there's nothing in here that's not related to SAPS. It might not speak directly to the terms of reference, but we are here. We'll hear from Mr. Chetty if he's going to feel like he's compromising his active cases or not. But the story of that prosecutors or whoever's going to be prosecuting his case are listening and is going to be prejudiced, I don't see how that has any relevance here at all. Everybody comes here and they say, I can't answer that because I have an active case. And we allow it. It happens many, many times. So it's up to Mr. Chetty. We are here. It's our fault here. We've let South Africa down. And Mr. Chetty will make the call. Thank you.
Bangazita.
Thank you, Honorable Chairperson. Yeah, I also do feel that it is unfortunate that we are engaged in such a discussion at this point. In fact, midway through the presentation of the chief evidence by Mr. Chetty, it's something that we should actually have dealt with before he came here. Now that he is here, and there are concerns about incriminating himself on some of the issues because most of the matters that he is actually presenting here are before court. I don't see how that is different from General Pahlane's cases, for instance, because he also had a string of issues that before court as I speak, and but I don't see any difference between Mr. Chetty's case and that of General Pahlane. So I feel it's up to the witness before us to decide what he wants to do. If he feels strongly that he needs to continue to ventilate his frustrations before this committee, so be it. Thank you.
Honorable Sols. May you switch off Bangazit.
Thank you, Chair. Look, I have many issues with our legal team, and sometimes with how logistics are handled with evidence or witnesses, etc. But today is not one of those days. I feel that this committee is wrong to, one, blame our legal team and the evidence leader. I disagree. And two, I further disagree that Parliament is an embarrassment. And that's not the message we must send to the country. Indeed, we have limited resources, but we must be honest about what has been done with the resources that we have. We have our evidence leader. We asked for a forensic investigator. You wrote to the Speaker, Chair. It's not like it was ignored. The Speaker responded. The Speaker said, we have Advocate Umkhize, who has forensic investigating skills, and she was intentionally appointed because she has that skills. And that replacement was because she possesses that skill. So now, with the limited resources we now have someone here with the investigation skills that we require. So we must not make it look like we are not operating properly here. We are doing the best we can. So I disagree with that position. On the evidence leader and the witness before us, when the witness was here the first time, the evidence leader was prepared to hear him. It is us as the committee who then asked of Mr. Chetty, because he said he realized that in consultation, the brief consultation they had, all of his attachments was not there. Then, Chair, you ruled that that would be unfair, so you gave it days to say, go get all the attachments to be fair, and then you come back. The evidence leaders follows our mandate. They go and they do that. Now they come back after days. They have the attachments. The evidence leader is ready to lead. We now blame the evidence leader for a mandate that we've given. We don't know Mr. Chetty, but we try to treat everyone in the same way. Lastly, in terms of our terms of reference, what are we meant to do? We are meant to hear anybody that says they can help us to get to the truth around infiltration, political interference, and defeating the ends of justice. We must test that. We did not invite Mr. Chetty. Mr. Chetty offered his information. So let him bring the information and let us test whether it helps us with our responsibility here. So I don't feel that the committee is in a bad position here. Number two, on the issue of Mr. Chetty incriminating himself, we must ask Mr. Chetty, we must give him an opportunity to say, and you must pose the question directly to him. Given the risk that you are potentially going to incriminate yourself by what you are going to present to us, we must ask him, are you willing to take that risk to potentially incriminating yourself by the information? If he says yes, that's consent. What must we do? We will then ask him, we will interrogate him. If he goes to jail because we asked him and he's found guilty, he's found guilty. He must go to jail. We won't visit you, Mr. Chetty. We will be glad that we've contributed to whatever the court will find if you are found guilty. But we can't sit here now and try and protect potential things. We must do our jobs. Just make sure, Chair, that we have his consent on record, that with all the information he's still willing to testify, and then we go ahead.
Thank you.
Thank you, Chair.
Honorable Vessels.
No, thank you very much, Chair. No, I share the concerns, and I've also, as honourable colleague said, I raised the concerns last night. I raised the concerns with regards to other witnesses before as well, and it's always met with, but we should be the parliament of the people and open to everybody. But, Chairperson, we do have a responsibility to protect Parliament from becoming a kangaroo court. I do not agree that it's the choice of Mr. Chetty if he is comfortable to continue or not. We should make that decision because we are at risk of and the problem lies with what the Honourable Souls say. We must test it. If we test the validity of the allegations made by Mr. Chetty, we're going to have a problem. The Honourable Matthys says that he can exercise his right to say, but this matter I won't respond to, it's in front of the court. Then we can just as well stand up now and leave, because everything that is alleged is in court, because even the allegations made are now in front of IPIT. And the witness already attested to that now and said that his allegations with regards to the alleged wrongdoing in terms of these cases are now investigated by IPIT. So we are in a peculiar situation where the relevance of this is also, it's really not relevant to our investigation currently. What is relevant, we can take note of, as other colleagues said, in the statement. Mr. Chetty is here, he confirmed that this is his statement. Let's take note thereof. Let's protect the integrity of this committee, but also of Parliament. And if we are going to go ahead, Chairperson, I'm very uncomfortable to participate, but Mr. Chetty must then also know that we are also in possession of an affidavit by Brigadier he's now Mr. Raman Jalam, who is in prison currently, who's a co-accused in many of these cases. We have that affidavit. If we're going to test the validity of the wrongdoing, we can't do that without exploring also the counter allegations and the evidence that's also provided that says it's the contrary. And then we are exactly where the Honourable Breitenbach said we are going. And we are not a court of law. These cases are in the court of law. Let the court of law decide what is wrong, who's guilty, and who's not guilty. Thank you, Chair.
Good morning, Honourable James. And
Hi, good morning, Chair. Finally. I strongly agree. We had this discussion, like Honourable Vessel said, we had this discussion later last night when we left. And I think it's just shocking right now. I always look at matters and I put myself out there and I think, what would South Africans be saying right now about us? I think that's almost the most important things that comes to mind. These people have brought a witness before them twice. And today they start off proceedings by debating whether he should be here or not. That is a disgrace. That is an embarrassment. I think the evidence leader have been subjected to this, to his statement, and I think they should have guided and advised this committee on the best way forward. I genuinely believe, Mr. Chetty, that you will compromise your cases if you proceed here today. And therefore, I also state that as Action SA, we're also a little bit uncomfortable with proceeding. Thank you.
okay. Before I give the evidence leaders and Mr. Chetty to make statements, let me say this, that I understand that when you are members of parliament, you are politicians, and parliament is a political institution. And today we want to discuss a procedural matter, and a procedural matter which is clouded by politics. Number one, who brought Mr. Chetty here? Mr. Chetty was brought here by the committee. It's a decision of the committee, Mr. Chetty, that you must be here. And there is nobody who is going to pass the bag and want to blame the committee secretariat or evidence leader. The committee in its own meeting took a conscious decision. Ramano was there, gave us a report. So we must take responsibility, honorable members. I always tell you when I'm here that the chairperson speaks the decisions of the committee. And if you listen to the summary that Honorable Sols gives here, Honorable Sols has given you the whole summary of what the committee has done. This committee further, Honorable Sols has said that the public submission evidences will not be led by statements which they would have prepared with the witnesses, but the witnesses will bring their own statements here. The public submission witnesses. Mr. Chetty has brought his statement. Why do you want to hold evidence leaders responsible for a statement that you said public submission witnesses must bring their statements before the committee? He brought his statement. And so what the committee has to do is to look for the needle in the haystack, separate chaff from grain. If you know what your terms of reference are, go through this whole statement and then look for what is relevant to your terms of reference than to prejudice the witness, either through the committee process or through any legal process. We run an oath every day here, and the honorable members are the ones who must know the oath more than the witnesses. Because the oath here says that any information or evidence or document that the witness presents before the committee cannot be used against him anywhere outside the House of Parliament or a committee of Parliament, unless in proceedings of perjury. Because when he's here, he's protected by the same provisions of the Act that we read to him. That's what it is saying, the oath that we take here. Unless if I'm giving it a different interpretation. But what is being said here is that the information cannot be used anywhere outside Parliament or... But the long and short of it, honorable members, is that this man did not come here, this witness did not come here by his own accord. He is a decision of the committee, and the Secretariat has even reported before us. You know what happened? When they reported that the person who made a submission before the committee cannot be found, it was this committee which gave the Secretariat details to say, go and call these people. These are their details. And they went there and did exactly what you have instructed them. It was this committee. It was nobody. It was not a member of the Secretariat or the evidence. It was the committee that presented contact numbers, digits one by one, in a committee meeting to say, call them. And they went out and called Mr. Chetty. He came. He's here now. So there is no way we are going to be temerarious here and try to gerrymander our rules. We are going to proceed with Mr. Chetty, let him present what he wants to present before us. And after he has presented, if you decide to keep quiet, and I will release him to leave and go back home. Thank you so much. We are going to proceed, no further discussions on this matter. Can we proceed, Advocate Arendse?
Thank you, Honorable Chair. I suppose that's the end of that discussion. I can't say anything further as the evidence leader about the process that brings witnesses before this honorable committee.
Don't comment on that. The chair has
Thank you.
has made a political statement. I don't want to put you on the crossfire. Honorable Sangweni.
Thank you, Chair. I also don't want to get caught in the political crossfire. Chair, can I ask, so we don't have this issue tomorrow? We're having 3 public participation witnesses. If my memory serves, there had been an issue that I'm not sure is Nicolette Ms. Prinsloo had raised about some of these witnesses, including Mr. Chetty and one witness that we are meant to see tomorrow. Can we request that before we maybe even break for lunch, that the Secretariat advises us on the witnesses of tomorrow and if indeed those witnesses should be? Because we had been advised against, Chair. Thank you very much.
Yeah, no, those witnesses are coming tomorrow. They are a decision of the committee, honorable members. Whether they come here to say anything or to say nothing, the committee has said they must come. So we are not going to change our decision at the 11th hour. We unless that they are unavailable, but any of those witnesses who is available for tomorrow, they are going to come here. Honorable Vessels.
Thank you, Chairperson. I just think it's important that we just remember that when the committee decides on the witnesses, we don't have the details, the statements, and the actual detail of what the case pertains to and what the witness is going to present to us. We raised the issue last week on when we received the statements of tomorrow's public participant witnesses. We raised the issue and we said we must look at that and the legal team must look at that because it does not seem relevant. And I repeat that, Chairperson, that I think we should, I support the Honourable Sangoni because they should look at that before those witnesses travel. And Chair, the same with this. I do not accept, with due respect, your statement that we decided. We did not have all the facts when we took that decision. When we get the facts, we can revise a decision. Thank you, Chair.
No, I hear you, but what is important, honourable members, you did not only decide. You decided and further instructed the evidence leaders that the public submission witnesses must bring their own statements here. Yes, maybe what we should be saying is that we could have said that let them look at those statements and advise the committee. But you said that no, they must bring what the evidence leaders do. They study the statement of the witness and look at how they can arrange it thematically. But without changing the whole statement or saying this must not go before the committee. So you can't want to apportion a blame on them for doing what the committee has instructed them to go and do. Honorable Nomval.
No, thanks, Chair. I hear your ruling on the matter. I disagree with you vehemently. We agree on witnesses, not on statements. We don't consult with witnesses. Witnesses consult with the evidence leader, and for a purpose. They don't consult with us. So it's wrong for us to be blamed for the work of the evidence leader. I still insist that the content of the statement, a person who can guide the contents, is the evidence leader. If it's not him, then who? Because by saying, Chair, witnesses can, public participation can bring their own statements to the committee. We are not giving an open-ended directive. That must be within the terms of reference, and because it means tomorrow we're going to wake up with a Bible here. A person who decides to submit a Bible to the committee and say, no, it's you committee members who said public participation can submit anything. No, there is guidance that must be provided by the evidence leader. I still insist you can defend him if you like, but I still insist, Chairperson, that the reason why we have the advocate here is for quality assurance. He must exercise his responsibility to say this is relevant, this is not relevant, this is within the terms of reference, this is outside the terms of reference, not us. Because if you are putting the blame on the committee, then allow the committee to consult with witnesses on their statements before they appear here. We get statements here in the morning. So we give a go-ahead under an impression that further work will be done on the nitty-gritties by the evidence leader, not by the committee. It was going to be a different case, Chair, if when we make a determination, we make a determination with a statement of a witness at our disposal. To say, if they can submit statements to us and say, this is what the statement want to present, then take a decision of whether he must come or not. Then we can be blamed for the content of the statement. But we make a decision on the basis of what has been presented to us by the evidence leader, because when they present, they say, no, this witness wants to come and testify on A, B, C, D, and E. Then we say, no, it's fine, we can go ahead. But there is no statement at our disposal. So I disagree, Chair, that is our strong view, but if there is an appetite of defending the evidence leader, then that's not my baby. It's fine, thank you.
Let's proceed, honorable members. No, we are proceeding. Let me tell you how we are proceeding. The statement that you have before you is not a statement that has any input of the evidence leaders. You know, when evidence leaders consult with witnesses that you have identified who come before you, they draw statements. Some witnesses sit with their lawyers and draw statements, and they submit to the evidence team. And the evidence team, when they lead evidence here, they select thematic areas on which they are going to lead evidence. So the statement that you have before you is not a statement that was written in consultation with evidence leaders. And that was your decision, that the evidence leaders have given you a statement that the witness has brought before them. And they have prepared their own notes on how they are going to lead evidence. So let's allow the evidence leaders to follow the thematic areas that they have prepared. And it's up to us as the committee to look at what is relevant to our terms of reference. Honorable Sols and then Honorable Breitenbach, you are the last.
No, Chair. maybe we must submit Bibles so that we can be reminded to be truthful. As the committee, even those public participation witnesses that's coming tomorrow, Honorable Vessels and Honorable Nomvalo must be truthful. We received it from the public. We brought it to the committee. The committee said, in the next meeting, table what is the content so that we make a decision. In the next meeting, I read the emails. The decision was made on the basis of that submission and a condonation was given. That's where we come from to this point. Then they had to provide their information, and now it's a matter of you must test what is in there. We must test it here. Whatever they present to us, are they giving us content that will assist us with our work? So we must not be untruthful and say we had no sight. This is public participation. It is not like the witnesses that is brought to be led by the evidence leader. So we are not defending the evidence leader. We are saying, and the secretariat, we are saying there are many things that we are dissatisfied with and we raise it. But today, this time, it is wrong to say the blame is on the secretariat and on the evidence leader. It is wrong today. Thank you, Chair.
Honorable Breitenbach, you are the last.
Thank you, Chair. I'm not blaming anybody. We find ourselves in this situation. I choose to deal with it as I find it. I am deeply uncomfortable with proceeding, and I request to be excused along with Honourable Karabona.
Okay.
Thank you.
Mr. Chetty, are you ready to proceed?
Chairperson, I am ready. Thank you.
Okay, thank you. Thank you so much.
Chair, we didn't hear. You must please let him state for the record he wants to. Knowing the information, and he's willing to do it despite what he knows.
Did you hear what Honorable Sol says? Can you raise your voice and put it on record? Are you willing to
I'm
proceed?
very willing, Honorable Member.
Okay. The honorable members have requested to leave and you occupy their seats.
Chair, you must say which honourable members and from which party have left proceedings. Because we've had so many people come here and they just tell us, I can't answer that, and nobody leaves. So we don't know how all of a sudden now there's a different stance of not wanting to be part of things. So please let it be clear, Chair. Thank you.
Yeah, I mean, it's unfortunate, but sitting here as the chairperson, I don't have any authority to detain persons in this meeting. Members of parliament, including witnesses. That is why the last time when we saw a witness standing up here and leaving, the least I could do is just to say, hey, Mr. Lkhanyane, ayo, Eloi, Eloi, lama sawatan, Lkhanyane, Eloi. There is nothing I can do. I can only say, why are you abandoning me? There is nothing more. So we are going to proceed, honorable members. Let's be humane enough. Mr. Chetty was here last week, and he spent the whole day with us. If you remember the time we made a decision that he must leave, it was towards the evening. And he spent the whole day trying to work on his statement so that it could satisfy the committee. And the committee met again, Mr. Chetty, on Monday and agreed that you must come today. You are here. We want to thank you so much for once again making yourself available, because we strongly believe that you have issues that you want to raise with us, and you believe they can help us in our work. So we are going to afford you that opportunity to raise whatever issue that you want to raise. You are under oath. We have read you the privileges that you enjoy here. I do not know, but that is how I understand the act, the provisions of the act that I have read to you. But because I'm human, I can have limitations, and I'm not infallible. If the provisions of the act that I have read do not cover you, I want to put it on record that you can't come and say the chair said this and that in the proceedings, and you want to use me as a defense. I think what must guide us here is that we are a constitutional democracy underpinned by what we call the trias politica, the doctrine of the separation of powers. That we do not make a call on judicial matters. The judiciary is the competent authority in terms of the doctrine of separation of powers that makes a call on judicial matters. And if you appear before a court of law, and the court of law says, but when you appeared before parliament, this is what you said, and they want to use that as evidence, they are the ones who are competent to make a decision whether the evidence you provided here in parliament is also admissible evidence in a court of law. And you cannot use parliamentary processes or mechanisms as a defense if there is a strong legal sentiment in the country that the evidence could be admissible before any competent court. So I just felt I must make that statement because law is science, and science can be subjected to different interpretations. Like you see, when we are here in Cape Town, the direction of the sun is not as I know it in Limpopo. That is science. So it can be differently interpreted, but at the end of the day, it remains the same sun with 12-hour day and 12-hour night, whether in Cape Town or in Limpopo. So let's have that understanding. So you said that you want to proceed. We are going to proceed with you, and Honorable Member has reminded me here that some of the witnesses who appeared before us, when there were matters that were still before the courts, they will respond by saying, I may not be able to respond to this question because it is before the courts. You get it? Yeah, so that you have rights as a citizen of this country. There may be a burning desire in you to share very important information with us, but your rights must not be trampled. And whatever case that you have before the courts, your chances must not be jeopardized because we would have asked you questions, and maybe out of excitement or agitation, you end up responding to those questions, and they jeopardize your chances. I just felt I must say those to you so that you can frame yourself in such a way that as a citizen with full rights, you have prepared yourself, you know what you want to come and say before us, and what you think can help us to further our terms of reference. Thank you so much. SC.
Thank you, Honorable Chair, Honorable Members. Now, Mr. Chetty, you are one of 70 accused in the what we described as the big case, the 335 case that was first opened in 2020. Is that right?
Yes, Chair. Yes, Council.
And then you are also one of 25 accused in case Silverton 143. You're one of 9 in Silverton 144. You're one of 23 in 145. One of 3 in 142. And one of 2 in 147. Are these other accused, are they aware that you are appearing here today and giving evidence before this honorable committee?
My family is, Chair, my family is, and some of the other members that I have access to is aware.
But the accused?
Yes, yes,
Or
yes.
some of
The
your family
accused.
members?
Yes, my family members are also accused
They're
in these
also
matters.
accused.
Yes.
And they know that you're here and they don't have a problem with you appearing?
No, they don't have a problem. And just want to put it on record, a couple family members and other accused also sent complaints to this committee, but they did not get any responses.
Now, some of the accused in all of these matters are also South African Police Service officers.
Yes.
Are they aware that you're appearing here today, or have they consented to you appearing here today?
I don't communicate with them often, only in court. I was in court 2 days ago, Pretoria Magistrates Court, and I did share it with, I think it was 2 or 3 of the accused that all are members in the police.
You're not concerned that some of some of your answers to questions or some of your statements that you may make voluntarily may compromise some of these other accused in these cases?
No, I'm not.
You're not
I'm not concerned because I am here. I don't think from listening to the other members that my annexures has been read, went through thoroughly, because I'm here on the abuse of power based on the terms of reference by the IDAC, by the NPA, which I have reference to everything. So yeah, I'm not concerned.
Now, not that any person or any accused can be abused by law enforcement agencies, or in some instances in your affidavit you also reference magistrates or the judiciary. Not that that's justified, but all of these charges are very serious charges. Do you accept that? Whether they're valid or not, they're serious.
They are serious, yes, Council.
And as one of the honourable members pointed out, that it is the prerogative of the prosecuting authority to charge an accused person. And that forms part of our rule of law. We've got, you know about the rule of law.
Yes.
We have, all of us have to conduct ourselves in accordance with the rule of law and with the Constitution.
Yes.
So given that these are serious charges, and the committee cannot ask you questions relating to the merits of any of these cases, why would you nevertheless want to proceed to give evidence before this honourable committee?
Counsel, are you meaning evidence on my charges? Or evidence or the merits of the case?
In relation to the merits, that's the charges, yes.
Yes. The evidence of the case is in court. Sorry, the evidence of the case are also in my annexures, showing the duplication of charges. That is it. So I just want to just bring us back here. The case that was struck off the roll, right? 342A-C was recycled and baby cases were made. So those charges that were struck off the roll, they just took out and recycled them and opened baby cases. That is why I'm here on the abuse of power. And one must remember, it's the same prosecutor, the same investigating officer, the same chief investigating officer. So they worked in concert. That is the main reason why I'm here about when we're going now to the charges of the case or the evidence of the case. They use the same evidence and charges in baby cases from a case that was struck off the roll. So the cases I'm facing in these small cases are all charges and evidence from a case struck off the roll. That is the reason why, one of the reasons why I'm here.
Well, then it begs the question. So what do you want this honourable committee to do about that? They have now recycled 335, which is the big case, recycled it into 4 or 5 other baby cases. And that for you involves a duplication of the charges. Is that your complaint?
That's my complaint. And as well, having multiple warrants of arrest against me approved on the same day by the same prosecutor, same investigating officer, signed by the same magistrate, taking me to different courts and executing it at different times.
Okay. But we also know then that the conduct of these prosecutors and law enforcement officers, that is also the subject of an IPID investigation which you have confirmed this morning.
Yes, Chair. But One must realize that this case that I opened was back in 2022, after I got the indictment of the case 143, where I was arrested in February. And the full cycle of this specific case of 12 of 7, where it went to, it went all over. It even went to Parliament. I have my proof here, whereby it also went to the late Tina Jomet Peterson. And then I received the email. As we're going through the affidavit, it's all there. So why I'm saying, only the day before yesterday, I get a call from IPAD stating the docket now must be collected and warning statements must be taken by these individuals. But let me take you a bit back. I received a letter from the DPP's office, 2024, December, stating that they declined to prosecute the matter. I then just asked for a nollie prosecution certificate. And now, I didn't ask them to review anything. The IPAD investigator calls me a day before yesterday and says, I have your docket now, and I need to take warning statements. So initially, why did they give me the certificate not to prosecute? And 2 days, knowing that I'm coming here, now they want to go and collect the warning statements from these guys.
So you read something sinister behind this, that on the one hand, the complaint that you lodged against these officials, where it was decided not to prosecute, and you got a nollie prosecute, is that right?
I got a letter, not a certificate.
Not certificate
No.
yet, but they decided not to prosecute.
Yes.
And now IPAD have opened up an investigation on the same complaint.
The case was always open. The docket was kept at the DPP's
No,
office.
but you said that the National Public
The
National
DPP.
Director, NDPP, had decided not to prosecute.
The DPP from North Gauteng,
from
yes,
the North
decided not to prosecute the matter. I then went to ask for a nollie prosecution certificate. We did not receive any response. I then sent Shamla Batoy a letter for the certificate in 2024 December. It's in my annexures. 2025, I received an email from an advocate, Erasmus under correction, stating that he's taking my matter under urgency. It has been quiet from then, but I did send him a letter asking, I want the certificate. I didn't ask you guys to review. You made your decision on not prosecuting the matter. So now, you sending me a response saying you're looking at it under urgency. It has been quiet since then. Nothing. Until 2 days ago. The docket is now back at IPAD. And now they're calling the 3 suspects to collect their warning statements. I find it very surprising.
Yeah, so isn't that where it belongs? With IPAD, whose main job is to investigate police or alleged police misconduct.
Yes, that's why it went to IPAD.
And that is there with the appropriate body that's been set up in terms of our laws to look into that kind of complaint, the complaint that you've lodged. You've also launched a High Court application to have these, what you call splitting of charges from the big case and splitting them into baby cases. You've also launched an application to have that dismissed. And I assume you are being represented by counsel, by lawyers in these cases.
Firstly, Chair, 12/7/2022 has a history before I got the call 2 days ago. It has a history where it went up to the DNC's office of General Sabia, and where the docket was kept with him for a long time. The docket also went to General Labia's office. But I'm just saying there's a paper trail of where the specific docket has been going to and how the system has been abused. And I received a letter from the DPP's office not to prosecute. So then full stop. I didn't ask them to go and investigate the matter further. I didn't. And it just comes to my amaze now, 2 days ago, I get a call. The docket is given back to the investigating officer by a prosecutor to go and obtain warning statements. So why have I been frustrated from 2022, going all over, up to General Sibia's office? And only when General Mkonazi's briefing, I then realized the suspects in this docket is the same suspects that those PKTT, or what do you call it, dockets were going to at IDEC, to Dylan Perumal. So I have a full circle on what happened with that specific docket. 12/7/2022, yes. So it's just not now that the docket is now at Mr. Baloy, at IPAD, and I must say, okay, fine, let's take it forward. To my understanding, there's a reason why the docket is now. Is there a reason why the docket is now back at Mr. Baloy?
Well, it could be that the fact that you had indicated, or they heard or know that you're coming before this honourable committee, maybe it's had the desired effect, that it's now with the body that is tasked with investigating these allegations of police misconduct.
Yes.
Maybe they are taking it seriously now. Because one of the remedies you would have had, absent the matter now being dealt with by IPAD, would have been for this honourable committee. I can't anticipate the committee's findings or recommendations. Would be, for example, to say, we had a witness narrating a string of abusive or allegedly abusive conduct, and this matter should now be referred, must be dealt with by IPAD. And that's where it is now.
I hear you, Chair, and I just pray that the process will be taken in obtaining these warning statements, because I also would appreciate the committee to call Mr. Baloy. Mr. Baloy was frustrated with the docket once he received it. Back in 2023-24, under correction, he received the docket. I will appreciate Mr. Baloy coming in from IPAD to explain what has happened with the specific docket. And also to put it on record, IPAD has another case of mine, 353 of 11/2022 of extortion by the same suspects, where they opened a string of cases against me. It's in my affidavit. So yes, I'm here on the abuse of this IDEC officials, taking me to different courts all over the province.
Maybe can I jump to something maybe more exciting, if I may put it that way. You say it's in paragraph 44 on page 74 of your affidavit.
74.
Yes, the very last paragraph actually. You say that you want to put on the record that Mr. Paul O'Sullivan contacted you regarding an article of General Masemola and a Louis Vuitton handbag. He was looking for information that could assist him against General Masemola.
Yes.
Why did you deem it necessary to put this into your affidavit?
I think it's about a month ago. It's on my annexures. If you refer to it, I was at home and I received a call, a WhatsApp call, which I didn't take at the time. I didn't know whose number it was. I then called it back, I think about half an hour later, and just before calling it back, I received a message from that number stating it's Mr. O'Sullivan, and he wanted to talk to me. I then told him now I was busy at a prayer and at home, and I said, no, I will talk to you tomorrow. I spoke to him the following day, and then he said to me that he's referring to an article that he has seen I think it's in the Daily Maverick regarding Louis Vuitton handbag. And then I asked him, why is he calling me about this article? He says, no, he wants information against General Masamula. And I just told him that he is aware that I'm coming to this committee, and I can't assist him in any way. And that was the end of the conversation. I did attach the WhatsApp conversation that he sent me on my annexure.
Did he call you perhaps because I'm trying to find the person's name, Mr. Rama. He's been convicted, and I think and he's one of the accused in one of your matters.
Mr. James Ramanjulam.
Yes.
Yes, I was arrested with him in 2020,
Yes.
and then I was again arrested with him and others in case 14320 in 2022. The execution of the arrest was in Silverton, but they took us to Palmbridge, and they detained the both of us with Beluchan putting an affidavit. I think it was his third supplementary affidavit stating that I want to kill him. James and I want to kill him and the team with no case number or anything. And then James and I was in prison, I think, for 39 days. We put in a high court application in for bail. I got, and he didn't get, because while in prison, we were detained. I think it's the 10th day, Sergeant Beluchan and the team came to arrest him again while he's in prison and took extracts again out of that case that was struck off the road, but this time took him to Randburg Magistrates Court.
Now,
Yes.
I want to ask about, what did you say his name was, Mr.
James Ramanjulam.
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 Now, he is still one of the co-accused in several of the cases that's pending. Or which case is he a
Counsel,
co-accused?
to be honest, I saw James in court the last time in Palmbridge in 2022. He was never brought to court. I only came to find out recently there is a 204 a witness, and he was never brought to court, and I don't know the procedure. Did he just disappears, or was he supposed to be brought to court and charges withdrawn, or saying that he's a state witness? But I've never seen him. I did see him after that in 2023. I went to visit him in prison. Yeah, this time in Kosimampo.
Is he an accused in 335, the big
Yes,
case?
yes.
And that case has now also been brought back.
Yes.
It's been brought back. Now, his affidavit was also next to O'Sullivan's affidavit that came before this committee. Okay. So that's why I'm curious to ask you, and if you don't know, that's fine. As a basis, perhaps, why he would have wanted to call you in connection with this allegation of a Louis Vuitton bag.
Okay. Counsel, when I opened case 12 of 7, 2022.
Okay, that
Right.
for the
Yes.
sake of the committee, that's your complaint.
Now, and explain to why he
Yeah,
contacted
this is
me.
the complaint against some of these.
Yes, the IDEC officials,
Yes.
the right, these three guys. And I found out that the investigating officer did see the national commissioner about this case that I've opened, and the investigating officer then told me he did see General Sibia. Right. It came to my attention that this IDEC official, Sunil Beluchan and Dylan Perumal, was going and using this case of the Louis Vuitton handbag to get appointed at the police. I don't know which section it is, but to be appointed without following the process. Right? I didn't send a letter to the National Commissioner, which is in my annexures, telling him, General, you are aware that these guys are the suspects in the case that are opened. And it came to my attention that you are on the verge of appointing them. And regarding that letter, it then got leaked out to the news. It was a news article. And that's how O'Sullivan, or that's why maybe O'Sullivan tried to contact me thinking that I have evidence against General Masamula about a Louis Vuitton handbag and not asking me anything about the IREG officials. That's
Okay.
it.
The reason why I also went straight to that allegation is because it also seems to be the case that you are connected with some high profile persons who's either with you and accused, or they have been accused, charged, prosecuted, and sentenced, like this other gentleman you referred to. And I wanted to lead on from that. How do you get to see and to speak directly with a very senior official like General Sabia?
Right.
Because, again, you're going to answer. It's not as if your complaints have not been heard or listened to by General Sabia, General Masemola. You've gone right to the top, isn't it? You've complained. So my question is, Sabia, how do you get to see him? How do you go? Do you phone him up? You WhatsApp him and say, I would like to see you? He's a busy man.
Yes. At that time, when I opened the case, the investigating officer then, Mr. Sergeant Shlangule, made contact with the National Commissioner, right? And that's when he told me he had a meeting with General Sabia and the National Commissioner regarding this specific case. And that's when I went personally looking for where General Sabia is. And many times I waited for outside his office, asking him, what's the status of my docket? That's how I met him, by the investigating officer telling me that the docket is moved now to organized crime, is no more at provincial, is at national organized crime now, but the docket is gone with the investigating officer under General Sabia. So I didn't know politics. I don't know politics. I don't know the system. Only after General Mgonazi's statement, I then understood why nothing was done to 12 of 7. Because General Sabia was very aware of the suspects and so forth. So I then understood why. So the investigating officer, Mr. Shlangule, should be called in and he will explain how it got to General Sabia and what happened from there. Yeah.
But what we do know from your narrative that nothing happened.
Nothing happened. I complained to Inspectorate. I met General Jacobs. I went there with one of my co-accused in our case 143, and we opened up a case there at Inspectorate. And the docket was then taken from General Sabia's office to Inspectorate to General Jacobs' office, and Colonel Phillips attended to us, myself and Marcel Mani. From there, Colonel Jacobs said we need to sign a consent form and send this docket now and others. It's not just 12 of 7, there's others against the same officials to General Libya at the Hawks. I left it. After some time, I sent the mail. I received the mail back from General Libya's office that they're not going to handle with the docket anymore and others. It must go back to General Sabia. And this is not happening overnight. It's taking over time just to frustrate me and make me not worry about the docket anymore.
Now, I'm sorry, I'm not getting his pronunciation.
Ramanjulam.
Ramanjulam. Now, Mr. Ramanjulam, you haven't seen his affidavit.
When applying for my bail relaxation in Palm Ridge, was last year, his affidavit was disposed to my legal counsel, which I had no interest in reading. Then 2 days, 3 days ago, I think Mr. Ramano sent me that same affidavit. Yes, but I did not read it.
Oh, you didn't read it, so
No.
I can't ask you about it.
No, I didn't read his affidavit because I know where that is based on. I know this man personally. I know what this IDEC officials did to him. So mentally, I was not willing to entertain that affidavit. I was concentrating on my stuff, my affidavit, and my annexures because it's going back for many years now. Because I have a paper trail on everything. I didn't want to go and frustrate myself with his.
Because I think you told me in our consultation that we had, the brief one, that you know that he was tortured. And so you didn't read his affidavit because you assume that the affidavit was made, or whatever he said is under duress.
100%, counsel.
Okay. So the reason why I asked you whether you had seen his affidavit is that if you do take the time to do that, maybe you should, before your various trials come up. He makes allegations against a lot of people and a lot of important people. And he makes allegations about the Louis Vuitton bags. You've seen that?
No,
sorry, you haven't seen it. And you'll also see if one goes through the list of 70 odd accused, and especially the natural persons, in the big case, the 335 case, he also makes allegations against them. So I think you should read it, especially if the state intends to call him as a witness. He, as we know, he's been prosecuted and he's a convicted criminal.
It's the first time I'm hearing that he is convicted.
You don't know he's in jail?
Nope.
Have you pleaded in any of these cases?
No.
So these cases, you don't know how far they are with investigating them, whether they're ripe for trial or anything like that.
From my last appearance 2 days ago, Advocate Shabalala puts on record that he is postponing the matter, reason being on the outcome of my High Court application. Because the High Court application has merits on all these baby cases and the 335 that he has brought back on the roll.
Now, I'm going to not ask you any questions in relation to any of these cases, because it seems to me to be a pointless exercise, given that we can't ask you about the merits of these cases. So I'm going to give you an opportunity, and then I'm going to end my questioning, to perhaps try and summarize the conduct of the various officials that you complain of, and perhaps with the prosecutor in this case, in all these cases, Mr. Shabalala.
It's fine. Can I go
Yes.
ahead? Can I start at the beginning, counsel? Right? And then I can run you down to how you obtained 3 warrants, executed different times, how he lied to the judge, he perjured himself. I have all. Can I?
Yeah, but I wouldn't. Obviously, I ask questions and
Okay.
speak subject to the direction of the honourable chair. But we need to restrict you to summarize the conduct of each one: Balochan, Perumal, Shabalala, Low, because that is at I think you conceded that, not conceded, but you said that at the beginning, when we summarize these matters, that's at the heart of your complaint, is that these 4 officers have made your life and your family's life a hell, isn't it? And I
Yes.
think you characterize it.
And the other
summarize it
accused.
as, yeah. So maybe just briefly on each one.
Okay. After the case was struck off the roll in 2021, 2022 February, 7th of February, Beluchan, Perumal, Shabalala, and the same magistrate signed a warrant. There was 3 warrants: 143 of 1 2022, 144 of 1 2022, 145 of 1 2022. Council, you must remember all of these warrants were signed on the same day by the same magistrate, same prosecutor, same IO, right? The first warrant was executed on the 7th of February 2022. I was then taken to Palm Ridge Magistrates Court, but on the warrant of arrest it says, take me to Court 16, Pretoria Magistrates Court. They rather decided to take us to Palm Ridge Magistrates Court, which is 95 kilometers away from Silverton, right? I was detained with others. On the 25th of March 2022, I was released on bail, right? On the 4th of June 2022, Beluchan and the team, it's the same people we're talking about now, Perumal, Beluchan, Shabalala. On the 4th of June 2022, they're outside my house. Happy anniversary. Because the initial arrest of the big case struck off the roll, they arrested us on the 4th of June. It was a Saturday. And when I got to the station, there was many other people there. That was on case 145. While processing me, he said, keep your bags packed up. I'm coming for you next week. Monday, getting bail. I got out Tuesday, Wednesday, Thursday, Friday, on my way to sign my bail, under my bail conditions. I get a call that they're outside my house again, executing the next warrant, 144. So that is abuse of power. Why did they not execute these warrants at the same time on the 7th of February?
That is 144 different to the charges in the
Same charge, just different case number. Same day, everything is the same, just the case numbers changes. Same magistrate, same prosecutor, same IO. Now, when
from the big
yes,
335 case,
yes. Now,
where you had already been arrested and appeared in court
yes,
on those charges.
yes, and the case got struck off the roll. Right now, on my bail application in 143, when they first arrested me on the 7th of February, right, in Palm Ridge, right? Magistrate Fenter refused my bail. I then did application in the High Court. Judge Musla asked Shabalala, the transcripts are here, is there any other pending cases against Chetty? He said no, but he rather had 2 warrants of arrest in his back pocket. That is what he did. And also put in mind that while again detained with Ramanjulam, we are still applying for our bail at the High Court. They arrested him again, whilst in prison. So that's why Ramanjulam abandoned his bail at Randburg. We're sharing the same cell, so I knew everything that he's doing. And he had to abandon the bail at Randburg. They brought him back to prison, and then Judge Musa says, no, he needs to sort the bail out in Randburg before coming to him. So I got out on bail, and he didn't. Now, after my arrest, the last arrest on 145 from those 3 cases, I then opened 12 of 7 in July. And then I filed papers at the High Court. That is a duplication of charges. In retaliation, Beluchan called me the next day, it's there, and he said that me and others must appear at the NPA building for a string of SARS matters that he has opened. But at the same token, earlier that year, SARS sent me a letter or correspondence stating that they're doing an audit, and I appointed a tax practitioner. So I was complying with SARS. So I was confused now. What's going on here? By this guy opening so many cases against us. And this is done at the NPA office, and there's no SARS official. But I'm complying with SARS on the other hand. At that time, Beluchan told me that I should remove my case, withdraw my case 12 of 7. That's when he told me to. Then I refused. It was just him, his colleague Ayanda, and I just refused. And I walked out of the office. There are many cases that he opened, the SARS matters. That is still in 2022. 2023, when I sent General Masamula the letter about his appointment, that's when retaliation came again. They arrested me again. But this time, the warrant is signed by Paul Lowe, right? But prior to that, on the 15th of February 2022, the investigating officer, Mr. Sriangule, called Mr. Shabalala to obtain a warning statement. And the following morning, Shabalala calls the investigating officer and says, General Sabia says you don't have to come and collect the warning statement. Only to find out, which I was told after I got arrested, Polo, I don't know, it's Matthew Sasoko, had a meeting with General Sabia regarding my case and obtaining the warning statement or proceeding with that case against this IDEC team. I didn't understand at that time what's going on because after I got out of prison, General Sabia told me that. This is what happened. Yes, Sabia. And he told me that. So then, when I got arrested, Sergeant Beluchan and the team puts an affidavit that I want to kill them again. Him and the team. And they just did this to silence me. Because in his affidavit, he states that I'm complaining to media houses and I'm complaining to the National Commissioner and Parliament. All my complaints are there. Complaining about them and nobody attended to me.
Yeah, your complaints is at paragraph 5.3 on page 16, where you reference your complaints to the National Commissioner, the Portfolio Committee on Police. I think that was when the late Timothy Peterson was still in jail back then.
Yes, and
Also then the Hawks, the Director of Priority Crimes, that's severe.
no, General Sabia was the head of organized crime at that time. He was the head of organized crime.
So you do, and the conduct that you've described in the few minutes that you. Sorry, my microphone is off. Sorry, Chair, I didn't realize my mic. Should I repeat So the conduct that you describe, Mr. Chetty, is also referenced at paragraph 4.21 on page 13, where you say the conduct of Perumal, Beluchan, and Shabalala leaves much to be desired. I am being portrayed as a perpetual offender with numerous cases pending before the courts. I submit that the pending cases amount to one case, which stems from the investigations and or contents derived from Silverton case 335/5/2020, and all this was done to spite me, and at the time it was on 1 June 2022. And since 1 June 2022, you say that this is continued.
Yes, Council.
But when you've been arrested and you appeared before the courts in various matters, the relevant certificates and warrants of arrest, did you see them? Were they shown to you? Did they at least appear to you to be warrants? Did they appear to be authentic?
Council, when we first got arrested on 1/4/2022 and taken to Palmbridge, my counsel did bring it to Mr. Venter's attention, the magistrate, that this merit is coming from a case struck of the roll, and we are not supposed to be in this court. We're supposed to be in court 16 in Pretoria. And Magistrate Venter looked past it. He looked past it. He didn't entertain it.
So is that your, what specifically is your complaint against, you reference Judge Mosa, Magistrate Venter, and I think one other magistrate also.
Right.
Is it, do your claims against them, is it because they ignored what you were saying, didn't take into account what you were saying?
No. Firstly, Judge Musa, what I'm not complaining about. I'm saying that he asked Shabalala, that asked him if there's any other pending cases against me, and Shabalala lied and said no, there's nothing. But he actually had 2 other warrants in his back pocket. Right? Magistrate Venter, he's the one that opposed my bail in February when we appeared there the 7th, right? On baseless allegations stating that I want to kill the team. On Beluchan's 3rd supplementary, I was there on a fraud matter, but on his 3rd supplementary, he says, now I want to kill him and the team, right? Magistrate Venter entertains it. We move on to our bail relaxation, which happened last year. After Magistrate Venter has opposed my bail, we were then moved to a different court, right? And I requested for bail relaxation, and the magistrate said then, submit your documents to Advocate Shabalala, and I will get everything, and we will sort it out. In the new court where I'm attending now, I never seen Mr. Venter after my bail was opposed. Never seen him again. Last year, after filing documents up and down, maybe it was on 4 occasions, sometimes Mr. Shabalala does not appear on the relaxation matter. We then go to the specific court. I think it's Magistrate Keswa. It's in here. And she then says, no, go to another court. The advocate and I goes to this other court, and amazingly, I'm standing in front of Mr. Venter again. I then tell my advocate, no, this is the magistrate opposed my bail. So we can't stand in front of him because he made his mind up already. And we then put an application for him to be removed.
So are you saying that a magistrate who refuses you bail, normally there'll be a bail hearing, did you get an opportunity to give evidence or for your counsel to make submissions, and the prosecutor would also make submissions or sometimes lead witnesses, and then the magistrate would make a decision?
Now
right?
we're talking about initially,
yes.
Mr. Venter. The whole application was done in front of him, and then he declined to give me bail.
Yes.
Yes.
Yes. So you say in another bail hearing he must be recused?
The relaxation of my...
Whether it's the relaxation, which is even which is not a denial, but just a relaxation of the conditions, that he should be recused?
On his behavior and the basis that I have on why he opposed my bail, I then spoke to my counsel and said, you know, this magistrate is not going to entertain anything regarding my bail relaxation. Because I'm signing 3 times a week. And if I have to leave the province, I need to inform the IO, which most of the time he gives me a problem. So I just stopped asking him. And when going back to Mr. Venter, the transcripts will talk for itself, whereby he says that he already made his decision on refusing to step down before hearing our arguments. And that's when I then told my counsel to abandon the bail, because he says it on record. There's no need for hearing of arguments. My judgment is made. So that's when I told my counsel, please, let's just abandon the bail.
And your other complaints against any other magistrate or presiding officer?
This is specifically on Palm Bridge. Other magistrates, you know, Advocate Shabalala just goes with the charge sheet and he just bombards any court. Counsel, I know you don't have a lot of time, but if you can see that a lot of times he keeps a charge sheet with him. A lot of times me appearing in court, there's no charge sheet. We sometimes wait for 2 hours, 3 hours. He says he needs to go and collect it from his office. Only for me to understand recently that the charge sheet is supposed to be staying at the court. So this is normality for him. This is normality for him.
Are you, in all these hearings, are you represented by counsel?
Yes.
So what does your counsel say about this conduct?
This is totally abuse of power. And that's why my counsel has put the application in. And regarding my application, it was put in 2022 on the removal of these matters. In 2023, this is when we supplemented it, only to find out in 2024, early 2024, the supplementary has been deleted off case line. Right? We then uploaded it again, added the annexures. Last year, Shabalala responds to the supplementary affidavit, but when we appeared at the court in June, was it last year, the Shabalala and the council of the MPA says that our supplementary and our annexures has been deleted. So one asks, how did Shabalala then respond to my supplementary and annexures when it's deleted? Because his affidavit is there, responding to our supplementary. But when getting to court, they tell the judge that there's no supplementary or no other annexures.
Okay. Now, we know that the big case, the 335 case, Silverton case, that case has now been re-enrolled. And there was a decision to re-enroll the case. Is that because the racketeering certificate has now been authorized or issued, which wasn't the case initially?
Okay. Counsel, the case was struck off the roll 25th March 2021.
Yes.
The basis, the state needed more time to obtain a racketeering certificate, right? From my understanding, the state could not get a racketeering certificate. That's when they opened the baby cases, 143, 44, 45. They then realized that we found out what they did. On the end of July, we then received a J175 to appear in Pretoria Magistrates Court. The summons is attached, the J175 is attached to my annexures. Right?
Yeah.
We then appeared at court and they gave us a CD with the summons. But this time, it's no more 655 pages, which was initial, it's now 450 pages. So it's common sense that they took the charges from that original case, they took out those charges and they opened the baby cases. Now that's why the case being brought on the roll is less now. The documents are less. But now,
What are you saying, that the baby cases collectively or together make up the same number of
charges,
pages or charges as 335?
100%. And there's proof here. Now, when the case was struck off the roll,
Now, how do we, as a committee, determine that that is irregular or unlawful or as you describe it, irrational?
the magistrate gave an order with 342A.
This is now,
Yeah.
I would expect, I don't know, but I would expect this to be part of your argument in the High Court, where your application is pending to have these charges
Yes.
set aside.
You know, counsel, I'm not here to prove my innocence. I'm not here. I'm here to show the abuse of power from IDEC, the NPA, the SAPS, the judiciary, whereby I have proof of how does one bring 42 people to court and you're not even on the court register. We're not on the court register. It's attached. The court register is attached on the day. I requested for transcripts from the transcriber on the day. It's attached there. I then go to the clerk of the court and request return of service and so forth on the J175, on that case being brought back. Up to date, nothing. The summons that we received, I approached the government printing works in Vasahi Street. They referred me to a deputy director. His name is in there. The email is attached. Whereby I went with the summons and he told me this thing has been superseded in 2014. Meaning, it's no longer valid. The summons we received, there's no signature on it. There's no signature. There's no charge. Just to put it, counsel, this summons was drafted out at a Protea hotel. I attached the location sent to me by Nico Williams. It was sent to me, and I went to go and collect the summons because the first time they wrote the summons out, they had a problem. So they asked me to come back. He sent me his location, and he's busy sitting with a stamp from the court, right? And stamping J175s in Protea Hotel in Hatfield. It's Protea Hotel, yes. And whatever I'm saying here, counsel, my attachments are there. So me and everyone else is appearing for this 335 case, actually illegally, where we're not even on the court books. And I personally, it's not getting from a third person. A lot of this information, I've done it myself over the years. So it's not anybody throwing documents under the table or anything like that. If you can see the summons that I went to Vasahi Street, there is a paper trail. If the committee wants to go and have a look and request government printing works to come, they're going to tell you the same thing as the guy sat with me and showed me on the system. The summons has been superseded in 2014. In Pretoria Magistrates Court, in other courts, the summons that we received is outdated.
Tell me, I'm looking at the section of your affidavit which deals with, it's on page 51, paragraph 11.1, SARS Financial Institution, and that's Silverton 353/11/2022. Does that relate to the charges of tax fraud?
Yes. That specific case that I opened, I then went, after my arrest for the SARS matter, after these guys called me to the NPA office and signing these warning statements for these SARS matters. I then went back to General Sabia's office. I didn't see him personally, but I saw one of the colonels or brigadiers there, and he told me he will send an investigating officer to come and take my statement, which he did. I then received a message the next day with the case number of this SARS matter. And I am aware that this case of 353 has been investigated deeply already by the investigating officer. Me as a complainant, she has told me everything that is, or most of the things that is transpired in this specific case now. But she has blockages at IPAD. Blockages because she has been going to Eastern Cape doing investigations, and as she's getting momentum, she has been stopped by IPAD, by her seniors, stating that there's no budget to go to the Eastern Cape.
The matter that's before the High Court, that matter was taken there on the 19th of March, 2024.
Page number?
Page 58, paragraph 12.10. And that matter was struck off the roll for a second time by Madam Justice Newkircher for a second time. So as I would again assume that it was struck off the roll because of a lack of urgency, but the matter, has it been re-enrolled? Have your lawyers put it back on the roll?
Now, counsel, this matter that you're referring to has to do with my AFU matter.
Or the asset forfeiture?
Yes.
It's a different matter.
But it emanates from...
Although it's related.
It emanates from 335 of 5/2020, just as I'm telling you about the summons that we received. And we were brought to court illegally, right? Right. So what Sergeant Baluchan and the team does, his affidavit is there. He uses a different court case number to go and apply for this AFU order on a rule nisi. His affidavit is there where he misleads the judge completely, he lies. He gets the order. Fast forward, we go to court, the matter is struck off the roll. When the matter was struck off the roll, the curator, Mr. Sean Williams, was supposed to release our assets. And I'm not talking about mine alone, we're many in this case. Under correction now, I'm not on the right page. The case was struck off the roll 3 times, if more. I have an email here from Advocate Wilson, who works with Advocate Shabalala, Low, and I will explain that later on, that he sent an email to the curator stating that he is aware that the curator is in possession of all our assets illegally because the case has been struck off the roll. And he's willing to keep our assets until the case is back on the roll, reinstated. Now, one can see here that once the case is struck off the roll and the system, let's call it the system, IDAC, these guys, don't get away. But the next week the case is back on the roll under urgent. They still don't get away. They still get struck off the roll. They do it again and again. Now this is completely abuse of power, whereby the curator is appointed by the master's office. He's not appointed by the NPA. I've been to the master's office. Unfortunately, I didn't attach so much information here. My records is at the master's office. And counsel, just to put it on record, when I approached the master's office, they said, yes, this is illegal. So I asked them, what is the remedy? My assets are frozen. I have nowhere to go. They're telling me I should go to the High Court myself and do an application. What knowledge have I got to do an application at the court now for what I'm telling them? Because they were aware now that, and they even took the documents from me of the fake summons. We didn't actually appear in court. The application was made to the AFU to court with a different court case number, which is not appearing initially. But where I'm getting at, the Mr. Wilson tells Mr. Wilson and Nicole Peters, because she works with the IDEC at the AFU, tells the curator they're aware that he has our assets illegally. Yeah?
Is that the complaint that your dad lodged or originally last
It has to do
year?
with the same
With the
curator.
curator, yes.
It has to do something, I didn't even read
So
my
that was
dad's.
originally the complaint that he lodged. Yeah.
Now, my main thing is when it's abuse of power shows with the NPA and the curator, whereby Mr. Wilson took instructions from Mr. Wilson. Williams took instructions from Wilson, stating that, we know you got these things illegally, basically, but keep it until we bring back the case on the roll. So they carry on putting the case back on the roll until they get what they want to reinstate the rule, Nisi. The court orders are there, it speaks for itself.
But Mr. Chetty, you are legally represented in all of these matters.
Counsel, the system, I have proof. If you want, you can take me by my hand.
Too much for your legal counsel.
No, you can take me by my hand. The members can take me by my hand. And all of Gentleman Gonazi's allegations, whatever his briefing is, I can physically take you and show you what is going on. And I'm not representing myself here. There's many people behind me, and also people have died. There's people in 335 that have died because of this abuse of power by Beluchan, Perumal, Shabalala.
Okay. Thank you. Honorable Chair. Thank you, Mr. Chair. I have no further questions. Thank you.
Okay, thank you. I was going to speak standing. So at least the microphone is now on. When you say you have no further questions, Advocate, do you mean you have come to the end of presentation of evidence?
Yes, sir.
Along the thematic areas that you have prepared?
Thank you. Yes.
Thank you so much. Mr. Chetty, you have 20 minutes before we break. Can I check with you if there is anything that you think you want to bring to the attention of this committee? The senior counsel has done what he felt was relevant for the work of the committee. And if there is anything that you think is also relevant in your own accord to the work of this committee, you can share with us. And if you are satisfied with the manner in which evidence was led, you can just say, look, Chairperson and honorable members, I think we have presented what was meant for this committee. Thank you.
Thank you, Chairperson. Right. In May 2021, James Ramanjulam opened a case against Sergeant Beluchan and Dylan Perumal. 97 of 5, 2021. There is a warrant of arrest against Sergeant Beluchan. Now, if you go back to the date, 2021, this was all in retaliation to arrest James, Romangulam, and others. But now again, let's go back to 97 of 5/2021. A warrant officer went to go and execute the warrant in East London. Polo, Richard Tyler Shabalala, Perumal, Brigadier Titiwe. I think it's in his statement, the Provincial Commissioner of Eastern Cape promised that Beluchan will hand himself over the Monday morning. Up to date, he has never appeared in court on this warrant of arrest. Now we're going back to 2021. What happened from there? We got arrested, I got arrested, and a lot of things has happened from then. So we go to 2023. I went to the magistrate's court, and then I went to the clerk of the court and I queried this case number. And they came back to me and said that the warrant is still valid on Sunil Beluchan. I said, okay. I then went back to Pretoria West Police Station. And the station commander was not there. I requested to see someone that can assist me with this case, only to find out this case has been undetected. And there's a duplicate docket open now. So I was confused now because I'm aware there's a warrant of arrest that's there, and now there's a duplicate docket on the same case, 97 of 5/2021. I went back to the magistrate's court on one of my appearances because I'm often appearing there on these different cases. And I asked, like, what is going on here? This was, I think, late 2023 with this specific case, because now I'm aware there's a warrant of arrest and now the case is closed as undetected. So I asked myself a question, doesn't this play with the statistics of the records of the SAPS? Someone then came to me when I appeared at court and they gave me a letter signed by Nico Williams that collected the docket from DPP's office. The same docket, 97 of 5/2021. The letter is in my annexures. He took the docket and went to go and give it to Sergeant Beluchan, who is the suspect and is in possession of his own warrant now. Now, I did bring this to the attention of IPID. I did bring it to the attention of IPID, and the investigating officers are aware of it. Now, Nico Williams came from Eastern Cape, who is one of the team members of this IDEC team. He arrested me many times. He takes the case to Zwelicha and its attention to Brigadier Perumal, who resigned from the police in 2020. So this docket of 97 of 5/2021, instead of it being in Pretoria West, it's in Zwelicha and it's in the hands of Sergeant Beluchan. Now, this case is from 2021 on May. How many arrests has Beluchan made having his own warrant of arrest with him? He arrested senior politicians. I've watched on TV. I was shocked. The same team again. And recently, I've seen on news how he arrested General Kumalo. But I asked myself a question. Now, this guy is untouchable. He has a warrant of arrest where he's in possession of, right? But he's busy arresting people and taking them to the same court where he must appear.
You mean his own...
warrant of arrest. It's J50.
So he must arrest himself?
No. He got a docket with himself, so nobody can arrest him. He said Nico Williams. The letter is here where Nico went to collect
so
it.
what you are saying is that a warrant of arrest has been issued, and because he's the one who receives those warrants, he's keeping it with himself.
100% sure.
So let's say so that we do an illustration for people to, if Honorable Ngola is the one who approves warrants, or he makes a decision that I must be arrested, and then when he has signed, and then for the warrants to be executed, they are sent to my office, and I'm one of those people whose warrants have been signed for execution, and then I keep my warrant, but I may release the warrants of other people. They get arrested and I don't get arrested because I'm having my warrant with me.
100%.
Who signed the warrant?
Pretoria Magistrates Court.
Let me say, before the warrant went to his possession, who signed it?
Who signed?
The warrant, yeah.
Meaning the warrant was there, the arrest was there. Who signed for the docket to be taken to him? Nico Williams, who is part of this IDEC team. It's one of his close
so
friends.
if this committee has to ask questions, who is the authority that we must address our questions to? To say, we hear that you have signed this docket, and there is this warrant in the name of Lakhanyane that is out but is not being executed. Who is the person that the committee can write to?
Chairperson, the owner of those warrants.
My understanding is that when you share this information with us, you are sharing this information with us to say, in your terms of reference that you are investigating, there are these corrupt practices that I'm observing in the system. Do I understand you correctly? And you, maybe as Parliament or as a committee of Parliament, there is a way you can intervene. Is that correct?
Yes. Because.
And so if we are to intervene, let's say we want to intervene, we want to write a letter for a written response to say, there is a witness who appeared before us. The witness has said the following. We want to know from you as the authorities. Do we write to the DPP? Who do we write to?
To write to the National
Maybe
Commissioner.
before you, let's hear Honorable Ngola.
No, let me help, Chair.
Yeah.
I think part of what is important was Mr. Chetty is mentioning the magistrate who signed off the warrant of arrest. So the best way from where I'm seated is to write to the Magistrate Commission to communicate with the magistrate himself to confirm or corroborate whether he has signed a warrant of arrest in this name together with his name, so that we get that confirmation. Whenever we want to deliberate around it, we have got the evidence before us. Thank you, Chair.
Thank you so much. Yes, you heard
Chair.
what he said.
Yes. But from my view.
Do you concur?
No. From my view, this warrant of arrest is there. It has been floating around all over social media. But unfortunately, from my understanding, you need the original warrant to execute a warrant, right? I did approach the police station where the warrant was approved. But on the system again, I'm showing you it's undetected. But here, there is actually a warrant of arrest. And this police station is aware that there's a warrant of arrest, but they is too scared.
Which is that police?
Police station, Pretoria West detectives.
And then who do you say is the relevant person there who can explain what you are saying?
The station commander should be aware of everything.
And who is that station commander?
I don't know who's the station commander. But the warrant of arrest is there, and he is in possession of his own warrant.
We had to, let's let's afford Honorable Ngola. Maybe he can be helpful.
Yeah, Chair, I think even in that instance, because he has the name of
Yeah.
the police station, he has the name of he has the dates and all the necessary details. So we may probably need to write to the Provincial Commissioner to give us that information because we want
we
it.
write to the National Commissioner.
Yes, we can.
He's the one who knows the people under his line of command or authority, who will then provide those details. You can proceed.
Chair, I think we didn't go through it. I first received, when I got arrested in February 2022, the 7th of February, now. In August, September, I received the restraint order by Advocate Wilson, Beluchan, the same team now. We're not shying away from anyone, the same guys. That is in 2022. They gave me a restraint order, another AFU matter on items of mine. But then they gave me another AFU order, which was in 2023. And again, it was duplicated.
When you say AFU, what do you mean? Because
Asset forfeiture unit.
oh, yeah.
So they froze my things twice, again duplication, by the same prosecutor, the same Advocate Wilson, the same people. These people are not shying away. They're not. It's not changing. The same people. And at this time, when I received my summons, the people that approached me was from the NPA with no number plates on their car. I sent a letter to the security at my estate. They said these people forced themselves entry. When receiving my summons, the sheriff, the lady that she says she's from the sheriff, gave me my documents, and I said, is there no receipt or must I sign? She said, no, you got yours, I got mine, bye.
So you want to say you were ill-treated?
No. I'm saying I was served the summons illegally, number one. Number two, it's the same.
Oh.
It's the same advocate, Mr. Wilson. And he called me directly asking if I received the summons.
You categorize it as unlawful action.
Yes. But now we're talking about the same team,
Yeah.
the same people.
Yeah. So don't you think that such matters are matters that you must raise? Do they fall? Do they go together with the case that has been opened?
It is in my iPad case. It is there, but only 2 days ago I get a call now from 2022 that it's with the investigating officer now. So up to the 2 days ago I was still hanging in limbo, not knowing what's going on.
Yeah, I'm saying that we may not be the relevant forum where you raise those issues, because if they are with IPIT, it's a matter between you and your lawyer that when you appear before IPIT,
yes,
you raise those issues for them to make the determination on the lawfulness or unlawfulness of the actions of those officers.
You see, Chairperson, I'm just here to show the abuse of power. Just court things that I'm sorting out. I will sort it out in court.
I agree. Let me tell you, because some of these issues now, they do not end with the currency of the ad hoc committee. Even after the lifespan of the ad hoc committee would have come to an end, you still have Honorable Cameron, who is a member of this committee, who is the chairperson of the Portfolio Committee of Police. That plays oversight. You have Honorable Ngola, who is a chairperson of the Portfolio Committee of Justice. So any citizen of this country can write to them as an oversight organ of Parliament and say, there are the following matters that I want to bring to your attention. And if you feel that they are not doing their work, you can still write to the office of the Speaker to say, I have gone to the Portfolio Committee, I've gone to Honorable Member so and so, I did not get the relief that I wanted. No, I feel that I must now write to your office as the Speaker of Parliament. Yes.
Yes, I understand.
Do you hear
Thank
what
you.
I'm saying?
I hear you.
Yeah. I'm saying that I'm giving you a chance so that when you leave here, if during the presentation of evidence between yourself and the evidence leader, you feel that there is something which would have fallen between the cracks, but you think must not escape these proceedings, you give us that information to say. Within your terms of reference, also look at the following. Yeah.
Yes, Chair.
You can proceed.
Where was I? Chair, you must just take it in consideration. I was arrested 5 times by the same prosecutor, the same investigating officer. And I'm not talking about me alone. We are many, many, many.
Yeah.
Same prosecutor, same investigating officer.
At Pretoria West.
First arrested in Silverton. The case got struck off the roll. Né? We went to Pretoria Magistrates Court. Then again, 143. It was 143, 144, 145. Same Magistrates Court, Pretoria. The first one, we were taken to Palm Ridge, but the J50 says come to Pretoria Magistrates Court. They took us 95 kilometers away. The second one, after appearing in prison and then coming out on bail, he is executing it on the 4th of June, saying happy anniversary regarding the matter that was struck off the roll. While processing me, he says, keep your bags packed. He executes the next one, the following Friday. Is that not abuse of power? Being arrested so many times in a short notice, having these 3 warrants and not executing it at the same time, when there's the same charge, same prosecutor, same IO, same magistrate signed it on the same day. That's why I've been fighting. I've been sending letters everywhere. But no one has been assisting. Chairperson, I understand. You're saying write a letter. I've been writing. There's a paper trail here of everything.
Did you write to them, the police and...
Yes, General Masamula, Andrea Johnson. I was amazed that Andrea Johnson knew my surname because she never responded to any of my complaints. But when she was here, she's talking about Chetty's allegations. But I'm like, wow, I didn't get no response from her. Yes, Shamila Batoy, she's aware of these cases.
Yeah.
You know, it's all there. It's everything is there.
I'm not the wisdom of this committee. Honorable members are going to interact with you when we come back. And obviously, if there are matters, there are no team matters that you present here. And members even go to an extent of suggesting how they think some of the matters should be processed. So I hope that all that you are presenting with us members are noting. We are going to allocate them time to ask questions. You will respond, and they will suggest on how they think your matters should be processed. Is there any other thing except your repeated arrest that you say repeated arrest by same people, and you view that as abuse of organizational authority?
Yes, Chairperson. And also, the courts, how they manipulate the courts by bringing public. It's obviously, this has been happening for a long time.
Yeah.
You're bringing people to court, but you're actually not on the court register. You're serving a summons which is fake. And in my view, it has not happened the first time. It's not happened the first time. It's just that I maybe found out and I just carried on digging, saying that there are many, many people appearing in court nowadays, and I don't even think that some of them should actually be in court. It's just abuse of power.
Okay. Do you have anything or further, Mr. Chet? It's 1 o'clock now. The members may want to break. We are going to Parliament. We are going to to come back at 5. Can you check? Can I check if the time I allocated you would have exhausted the matters that you wanted to raise with us?
No, it's fine. It's fine. I'm fine. Thank you, Chair.
Thank you so much. Honorable members, I'm coming back to you. We are going to come back to our proceedings at 5. We are going to resume at Good Hope Chambers. Let me see. How many of you will want to ask the witness questions? Okay, no, we have a reason to come back at 5. Because when we started, it was like you did not have questions. But now I see you have. Can I check, Honorable Ngola, what is the time that you suggest we must allocate to you?
5 minutes, Chair.
5 minutes?
1, 2, 3, 4, 5.
Okay. So it's only you from the ANC will be asking questions?
Only me, Chair. Thank you.
Okay, thank you. From MKP, I see Honorable Nomvalo and Honorable Skosana. 10 minutes. How many, Honorable Skosana? Good afternoon and welcome. Thank you so much for your resilience. I can see you have not been well for the past 2 days and you requested to go and consult. But you are showing your resilience. Yeah. How many minutes will you want? Honorable Skosana? And Honorable Nomvalo, you said 10. So the two of you combined is 40. Okay. Honorable Matthews?
30, Chair.
30 minutes, yeah. Bangazita?
15.
15. Okay. Honorable Sols?
30 minutes, Chairperson.
30. No. Look, there is nothing funny about it. Honorable Sols is very loyal to the committee decisions because the committee has said that each and every speaker will be allocated 30 minutes. So he's very loyal, unflinching to our committee decisions.
It says a maximum, Chair, of 30 minutes.
Eh?
It says a maximum of 30 minutes.
He uses the maximum. He plays 90 minutes. Honorable Vessels? Nothing. Not even a second. Okay. Honorable James?
5 minutes, please.
5 minutes. Okay. It means today we may be done around 7:30 or 8. So I will use the remainder of the time between the time you finish asking questions and 10 o'clock will be used by the chairperson. So that we stay true to our finishing time of 10 o'clock and 11. So you will be patient with me tonight if I engage the witness for 2 hours. And then, Bonani, may we just make sure that all the witnesses who are coming tomorrow, we confirm with the members today by close of business that we have been able to get all of them. Yeah. Thanks very much, Mr. Chetty. Thank you so much, Advocate Arendse. Honorable members, we are now going to break. At 2 o'clock, we are expected to be at the dome. Is the dome? Yeah. For the business of the National Assembly. And once we are done, we will gather at the Good Hope Chambers for members to start engagements with the witness. Thank you so much. May we please stand up and leave the chamber.
Madam Speaker,
May we now have a moment of silent prayer and meditation. May we be seated. At least I see the smiles today, meaning that the moment of silence was adequate. Honorable Skosana, what is the point of order?
Thank you very much, Madam Speaker. Madam Speaker, I'm a bit surprised why it's so hot in this hall. I think we must go back to the other committee. We are not used to what is happening here. It's too hot. It's too hot. There's no air. The government can't run a simple thing, a simple air condition.
You are unfit, Jimmy.
Honorable members. Honorable Skosana, thank you very much. We do take note of what you are saying, but as you know, there is heat wave. We have tried the best we can. Aircons were opened at 10 this morning to make sure that at least we cool the place. But seated here, I can also feel the heat. It is hot. And I hope we will do the best as we can so that we can finish the questions much earlier. About the ad hoc committee, I'm not sure. You'll have to write a note to your chairperson whether he wants you to go back. Thank you very much, honorable members. Today is questions to the President. The first question is from order, honorable members. I'm sure you are happy to see the President, so you are conversing across the board, but the only item on the order paper, as I said, is questions addressed to the President. Honorable members will recall that on 2nd December 2025, the National Assembly to amend rules on questions for oral reply. The amendments include that the number of supplementary questions to the President is increased from 4 to 5. The members in whose name the question stands will have the first and the last of the supplementary question. The question time allotted to the President remain 3 hours. Parties have given an indication on which questions their members wish to pose a supplementary question. Adequate notice was given to parties for this purpose. The members who will pose supplementary question will be recognized by the presiding officers. In allocating opportunities for supplementary question, the principle of fairness, among others, has been applied. When all the supplementary questions have been answered by the President, we will proceed to the next question on the order paper. Honorable members, you also know that in terms of our rules, that a member who might have asked a question and is not in the House will ask another member to take a question on his or her behalf. But also when a member may be in the House and the member is not able to do so because of health reasons, he may request that his or her question be taken by another member in the House. So I want to indicate that the Honorable Chief Whip, Honorable Ntuli, who asked the question to the President, is here with us in the House, but he is incapable to ask a follow-up because his voice is not there. Order, honorable members. So he has informed the table that he will ask Honorable Mika to take the follow-up question. I would also like to recognize Honorable Nkabane, who has been appointed by the African National Congress as the Deputy Chief Whip for the largest party. Honorable Nkabane, I hope will be able to join the whippery and work with your colleagues and make sure that this House is functional as the whip. That's part of your responsibility. The first question has been asked by Honorable Mtumiseni Ntuli. The question is, in the light of the fact that the Commission of Inquiry into Criminality, Political Interference and Corruption in the Criminal Justice System provided him with an interim report with referrals and recommendations, which he accepted but decided not to make public, and noting the public interest on the matter and the need to ensure transparency, what are his reasons for deciding to withhold the report from the public? Honorable Mr. President.
Deputy President Paul Mashatile, honorable members, thank you, Honorable Speaker. The establishment of the Commission of Inquiry into Criminality, Political Interference, and Corruption.
Order. Mr. President, can you please take your seat? Who is taking a point of order? Honorable Reddy.
Thank you, Honorable Speaker. I rise in terms of the rule that was quoted.
Honorable members, can we hear the member?
It was quoted yesterday by the acting Speaker, Honorable Frolick, in which he said that members answering questions should not take to the podium. I'd just like some clarity, please, on whether this is allowed. Thank you.
Thank you, honorable members. I will consult with Honorable Frolick on that new rule, but as the rule stands, the President can take the question on the podium. Mr. President. You can take it from the podium, Mr. President.
Okay. As I was saying, Honorable Speaker, the establishment of the Commission of Inquiry into Criminality, Political Interference, Corruption into the criminal justice system is indeed a matter of public interest. The Commission's interim report, which I received in December, made recommendations with respect to matters where there exists prima facie evidence of wrongdoing. As directed by its terms of reference, the Commission made recommendations that can be classed into three areas. Firstly, the Commission referred several matters where it found evidence of wrongdoing to the relevant institutions for immediate criminal investigation. Secondly, the Commission directed that there should be urgent decisions on prosecution where required. And thirdly, with respect to individuals currently employed within the law and intelligence services, where it was found on a prima facie evidence that there was wrongdoing, the Commission made a number of recommendations regarding the employment status of such individuals, including whether they should be suspended pending the outcome of further investigations. Now, to ensure that these matters are given the necessary attention, I directed the Minister of Police as well as the National Commissioner to constitute a special investigation task team reporting directly to the Commissioner. The team will institute investigations against those identified by the Commission for such investigations. Matters that require disciplinary action are currently being attended to by the relevant departments. And some are resulting in suspensions and some are resulting in immediate disciplinary processes that are now underway. The Commission's work is ongoing. In its interim report, the Commission noted that it will require further evidence from a number of people who had not yet appeared before it. Now, beyond the referrals and recommendations that I have made public, it would be unfair to witnesses whose testimony is not complete or individuals against whom the Commission has not yet made any findings to publicize the information at this stage. Furthermore, it may jeopardize investigations as well as lines of questioning of the Commission to make unconcluded avenues with regards to the investigations that could be made public. Given the short time frame in which the Commission is expected to complete its work, we will make sure, and in fact, I will make all the reports public once the Commission has submitted their final report. The Commission has been given a tight time frame within which they should produce another interim report, whereafter a final report. Now, this will be subject to any advice from the Commission itself or other considerations on whether the publication of any portions of the report that may put persons who may have appeared before the Commission in danger. Now, we have already seen how a number of people who appeared before the Commission have been targeted, and some of them have been in serious danger. So the information will be made public subject to the advice and discussions with the Commission as well. Throughout this, we have been guided by the fundamental principle of transparency, and that South Africans must know the facts around the allegations that were made by Lieutenant General Mkhwanazi and must know what action is being taken to address any wrongdoing or systemic weaknesses that are identified. I am on record as having said that we will implement the recommendations from the Commission and we will take action. I thank you.
Thank you, Mr. President. The first supplementary question will be from Mika, Honorable Mika Msauli.
Thank you very much, President, for the response, particularly as it relates to your reason that it would be unfair to disclose the report because by doing so, it will be prejudice. It will prejudice witnesses who have not appeared as yet or concluded their evidence. However, Honorable President, you have referred for action a report you received on the 17th December 2025 and on 29 January 2026. For action, a report accepted recommendations against individuals who had not appeared before the Commission or given evidence. For instance, Brigadier Rachel Mateng only appeared before the Commission on the 5th and the 6th of February 2026. Major General Richard Shibir only appeared on the 4th and 11th of March 2026. How do you justify your response that disclosing the report will be unfair to witnesses whose evidence had not been concluded when you accepted recommendations relating to some people without having given evidence, and how did you logically apply yourself in this regard? Thank you, Mr. President.
Thank you, Honorable President.
Thank you. Yes, that's precisely what I was trying to address by saying that there are certain witnesses who have not yet appeared, who, however, the Commission has actually made some findings on. And we will be taking all that in totality as we release all the reports. The reason, particularly the one that you are mentioning, is precisely that any witness who goes before the Commission should not feel that they've been prejudiced by the upfront release of the information or the report. They should go to the Commission and present their story, even as the Commission itself will already have said something about them which would have led to us taking certain actions. Thank you, Honorable Speaker.
Thank you, President. Honorable DDD Van Rooyen.
President, I hope you still remember that this country doesn't have a Minister of Police. I hear you referring to tasking the Minister of Police and the National Commissioner. The Minister of Police is in suspension. We are currently having the acting Minister of Police. I hope you are not referring to Senzo Mchunu. In the interim report, as you are all aware, it deals with criminality and political interference within the criminal justice system. South Africans will naturally worry that powerful individuals, like your relative, Maumela, who you are connected to, and they are also connected to those in authority, may be shielded from scrutiny. Therefore, can you assure this House that none of the decisions to withhold the report or delay its publication are intended to protect politically connected individuals, including those with familiar or political proximity to your office? But also, what concrete steps have you taken against the implicated, including whether Minister of Police, Mr. Senzo Mchunu, is subjected to any action arising from the report?
Your time is up. Honorable President.
Thank you, Honorable Speaker. Minister Firoz Kachalia is, yes, acting Minister of Police, and in fact, Minister without portfolio with the responsibility of overseeing the work of the police. So the Minister is doing his work, and when I refer to the Minister, I'm referring to Minister Firoz Kachalia, or better still, Professor Firoz Kachalia. I can give assurance that no one who's either implicated or will be implicated will be shielded. And when the Commission does its recommendations, we will act accordingly on those recommendations. I have already gone on public, Honorable Member, to describe the relationship between myself and Maumela, and I do not wish to get into that because continuous peddling of that information, which is actually misinformation, is completely incorrect. And in the end, we will make sure that when the report is issued, the South African public will be able to see what the Commission said and what action we are actually going to embark upon. So no one, no big name or small name or whoever, however they are connected, will be shielded. We can assure you of that. Thank you, Honorable Chairperson. Speaker.
Thank you, President. Honorable S.S. Zibi. Honorable Zibi is a new one. Okay, Honorable Kana.
Nitavutisa on behalf of Honorable Zip. Na Cancer President. So, xin'wana nga xi vona, President. I ku ri since even before press conference ya General Mkhwanazi, ku na tinyimpi hala ndzeni ka maphorisa. And loko mi vulavula ka State of the Nation, mi te ku va na vetting exercise eka senior members ta maphorisa. So na ku twisisa ku ri no, since announcement ya n'we leyi mi nga yi endla eka State of the Nation, what work has been done to vet and stop the infighting that's currently paralyzing the South African Police Service? Because if anything that comes from the Madlanga Commission is that the police continue to be fighting and not protecting the people of South Africa.
Thank you, Honorable President.
Na Cancer. So sweswo hi swona hi swi langutaka. hi te ku ta endliwa vetting ya maphorisa ka kumbe lava va ri le henhla. So i sungurile vetting ya kona, and i sungule vigorously. I ta endliwa ku ri i ze yi helela. Hi kota ku tiva ku ri i maphorisa lava va tirhaka, i maphorisa va tirhelaka vanhu kambe va ti tirhela vona. And na leswi swa ku lwa xikarhi ka maphorisa hi karhi ha swi languta. Madlanga Commission I hi pfuna hi ku sweswi se hi tiva kahle ku ri ku na ti-camp a karhi ka maphorisa. So sweswo swi endla ku ri ntirho wa maphorisa u nga endliwi hi ndlela leyi hi rhandzaka. So swi ta lunghisiwa hinkwaswo sweswo. And of course, what the Madlanga Commission has revealed is that there are divisions in the police force, particularly at the higher echelons. And there is a whole problem of capture by criminal syndicates. As the evidence is unfolding, we will hear from the Commission precisely what their final recommendations are. And it is upon that we will be able to take action. Thank you, Honorable Speaker.
Thank you, Honorable President. Honorable Trollip. Okay. Honorable Member who's taking a question on behalf of Honorable Trollip.
No, thank you, Speaker. I will take the question on behalf of Honorable Trollip. President, good afternoon.
Good afternoon.
The list of senior police officials and government officials and politicians that you have appointed to serve in your cabinet who have been implicated in criminal conduct continues to grow by the day and is being exposed not only through the testimony before the Madlanga Commission, but also through the ad hoc committee here in Parliament. This raises a fundamental question, President. When those mandated to lead the fight against crime are themselves implicated in serious wrongdoing, who is actually protecting and fighting crime on behalf of the people of South Africa? And also, what assurances will you give the people of South Africa that you will implement the recommendations of the report much more than what has been done with the Zondo Commission, which cost the fiscus billions? Thank you.
Thank you, Honorable President.
Let it be said that, starting with your very last paragraph or statement, we have been giving reports on the work that is being done to implement the recommendations of the State Capture Commission, which was headed by Justice Zondo. We keep on reporting, and at the presidency level, we keep on giving updates of what is being done. The work that has been done is quite considerable. And of course, people have always wanted to see big names being charged, big names being put in prison. Those are the main areas of focus. However, Justice Zondo's commission made many other fundamental recommendations, some of which have had to do with how we should reform our laws, how we should amend our laws on issues like procurement and so forth. And all that work is underway, and how we should ensure that we bring down the levels and incidents of corruption. So that work is carrying on, and I will continue to stand here and give full reports of the work that is being done. With regard to giving assurances on the implementation of the Madlanga report, I have said, and I say it again, we will implement the recommendations of the Madlanga report as we are implementing the recommendations of the Zondo Commission. Now, as regards that, people want to see people being arrested. Processes, legal processes are underway. And those processes in our own country, in terms of our constitution, do tend to take some time. And I would say frustratingly so. They take their time, and they must be allowed to take their time so that there is proper and full justice. And yes, many people can be implicated. People do tend up and make a whole lot of statements about people. What I have always said is that we do need the evidence, and the people need to be charged so that the criminal justice system, which we all subscribe to, should take its course. Because at times, whenever allegations are made, sometimes they are found not to be true, and people are then found to have been either blemished without the real substance. Where there is substance, charges must be preferred, and people must then be dealt with. If they have to step aside or step down, they will step down. If I have to take action against them, I will also do so. So evidence is important, and following our judicial system, our criminal justice system, and the tenets of our Constitution is also important. Thank you, Honorable Speaker.
Thank you, Honorable President. Honorable Sauli.
Thank you, President. You noted in your response that it will jeopardize the investigation and the line of questioning of the Commission to make an incomplete investigation public. Did you consider the principle of natural justice when you accepted the recommendations of an incomplete investigation?
Honorable President.
Yes, I did consider the principle of natural justice and had to balance that with what the Commission had put out. And in balancing that, and of course, in also considering the report in its totality, we have been able to use natural justice. In the end, through the process of our very robust judicial system, whoever either has been implicated or been dealt with from a disciplinary point of view or will be charged will be able to have adequate opportunities to answer to those issues that have been put to them. So when we have taken action, it's action where there is substantial evidence that we could act on, but based on natural justice. Thank you, Honorable Speaker.
Thank you, Honorable President. We now move to question 2, which has been asked by Honorable Jimmy Khalakis, the Chief Whip of the Democratic Alliance. The question is with reference to the announcement he made during the State of the Nation address on 12 February 2026 that a National Water Crisis Committee will be established in response to the country's water crisis. What step has he taken to ensure that the recommendations of the committee will be implemented in municipality facing water crisis? Honorable President.
Thank you, Honorable Speaker. An unreliable supply of water to our people places a heavy burden on their lives and the ability of businesses to operate and thus to grow our economy. That is why in the State of the Nation address in February, I directed the establishment of the National Water Crisis Committee, which we now call WaterCom, to ensure a coordinated response to the water crisis. Work is currently underway to finalize the National Water Action Plan and to get the committee to start its proceedings, which it will do this coming week. It is expected that it will be completed by the end of March in terms of the water plan. The National Water Crisis Committee will focus on 3 priorities. The first is to address immediate challenges in municipality water and sanitation delivery through a focus on limited number of municipalities. Secondly, to expedite institutional, financial, as well as regulatory systemic causes of the water crisis. Thirdly, we will attract investment in water infrastructure, increasing both public and private sector investment, and involvement. The main causes of the water crisis are at local government level. Maintenance of municipal water and sanitation infrastructure has been neglected in many of our municipalities over decades. There is therefore a big deadlock or a huge deadlock for the repair and refurbishment of water services. In Johannesburg alone, the pipes that deliver water to industry and to our household, to the households, are old and are in need of repair, and the budget to do so runs into hundreds of billions. The situation has been exacerbated by a lack of capacity, also organized crime, widespread theft of water infrastructure, corruption, poor billing and revenue management, as well as illegal connections and water leaks. Solving South Africa's water crisis, therefore, Honorable Speaker, requires what I would call a multifaceted approach, focus on institutional reform, infrastructure maintenance, and human capital development at the local level. We need to focus our attention on strengthening the capacity of water services authorities so that they are able to manage this very important resource of life, water. They also should be able to reduce demand and maintain official systems effectively. Where necessary, existing powers that are outlined in our Constitution, as well as in the National Water Act and the Water Services Act, will be used to intervene in municipalities that are failing to meet their obligations or are failing to implement corrective measures. This will include assistance to those municipalities, working alongside them to execute their responsibility, and at times even taking over. We will also, where municipalities and municipalities officials fail, be able to take action against them, and we will also be focusing on how they are contravening the requirements of the National Water Act, and if there's wrongdoing, they too will be charged. Where necessary, national government will assume responsibilities for water services in those municipalities that fail, as I said, to discharge their responsibilities. The amendment of the Water Services Act will enable stronger intervention where a water service provider, for instance, fails to adhere to their license conditions. In addition, we are also implementing the Metro Trading Services Reform Program. Now, this is a performance-based incentive that is worth 54 billion rand over 6 years to overhaul electricity, water, and waste services in South Africa's 8 metropolitan municipalities. The program itself introducing an incentive-based grant system that rewards metros for improving financial management and achieving specific service delivery targets. Now, this program, Honorable Speaker, aims to reverse long-term service decline in municipalities. It will also improve financial sustainability and unlock additional investment, as has been done to great effect by the National Electricity Crisis Committee. We see the National Water Crisis Committee being able to bring together various role players across the state as well as outside government to undertake a clear set of focused and impactful interventions that will make a real as well as a lasting difference to people's lives. Now, we are going to be proceeding to implement this plan, and like we succeeded with electricity, I have no doubt whatsoever that we will be able to achieve great success by harnessing all the resources of the various stakeholders to enable us to change the course of our water supply, reticulation, and distribution in our country. Thank you, Honorable Speaker.
Thank you, Honorable President. In accordance with Rule 137, subsection 10A, I would ask Honorable S.J. Moore to take the question on behalf of Mr. G. Michalakis. Honorable J.S. Moore.
Thank you, Mr. President. Mr. President, your Minister of Water and Sanitation revealed yesterday, and you've just confirmed, that the National Water Crisis Committee has not yet met, despite the announcement a month ago. Mr. President, a month is a long time in a crisis. This is while people are currently suffering. You mentioned the city of Johannesburg, my hometown. Due to Johannesburg's sweeping financial arrangement that takes infrastructure funds away from Joburg Water, it has emerged that contractors are owed hundreds of millions as projects across the city stall. You also lead the Presidential Johannesburg Working Group, which was launched over a year ago. So there's plenty of interventions in this space, but taps are still dry. Will you, Mr. President, rebuke Johannesburg's sweeping policy that takes away infrastructure funding and call for the ring fencing of water infrastructure spending? Thank you.
Thank you, Honorable President.
Thank you, Honorable Speaker. There have been various meetings that deal with the challenge that we face of water. In preparation for the very first meeting of the National Water Crisis Committee. Now, preparations have been made. The clear plan has been put together, and it is presented at the meeting this Wednesday, where I will be present, and the Deputy President will be present, as he's been leading the other process as well, which has done extremely well in terms of defining what the real problem is. We will, from those meetings that have been held, consolidate the views that will be coming from all key stakeholders. And we will then be able to take this matter forward. I'm meeting with the Minister of Finance later this afternoon to discuss precisely the financial issues that need to be upscaled. Minister of Finance did decry, as he presented his budget, the fact that a number of municipalities get revenue for water and then they divert it to their other cost centers without actually ensuring that the money that is brought in as a revenue from water is actually used to promote or improve the infrastructure of our water resources. And it is for this reason that participation at government level, including the various ministers, will be participating in this committee so that our intervention is more impactful. So much as the committee has not met, as the minister said, it meets on Wednesday, but it will be now bringing together all the preparatory work that has been happening and clear proposals and recommendations. Johannesburg Presidential Working Group is also going to meet. I had a meeting last week with the eThekwini Presidential Working Group, who were reporting to me the great progress that they have made since the working group was established. I await a similar type of engagement with Johannesburg to deal with all the challenges. And as we establish this working group for eThekwini, water was a major challenge as well. it is now being addressed more effectively with the participation of a number of entities, private sector, public sector at all levels, national, local, as well as provincial. The same thing should then happen with Johannesburg. We are all equally concerned about the slow pace that is being made in Johannesburg. We are going to seek to arrest that so that we catapult the work that is being done in Johannesburg to a higher level. And we will be focusing on this to ensure that Johannesburg is turned around in all its ramifications with regard to water, as well as the challenges they have in electricity, as well as general municipal services. So we will be attending to all that. Thank you, Honorable Speaker.
Thank you, Mr. President. Honorable Mentor.
Thank you very much, Speaker. Good afternoon, President. President, accountability should be promoted, especially by you. We can't start by introducing new strategies of crisis committees without consequences. The crisis of water is as a result of your incompetent deployees of the ANC and Tagarism. We have heard nothing about what happened to those officials as well as political heads. And you should also start by apologizing to the people of Guyana, whom have not been having water for the past 15 years. Today we hear that their budget has moved from 248 million to 6 billion without accounting as to what has happened. For the past 15 years, no one is accountable for water losses and for us not having water in this country. President, we should not move forward without knowing exactly what are the terms of reference of this crisis committee, because your government has been doing what is called privatization of entities. We have seen privatization of ESCOM, and recently we have seen the privatization of Home Affairs under your government. Is our water safe? Are you not going to give our water resource to the private sector? Thank you.
Thank you, Honorable President.
Thank you, Honorable Speaker. Let me start off with the challenges that our people in Guyana have been facing. The project that we focus our attention on in Guyana is between 90 and 92% complete. And it involves about 335 kilometers of bulk water pipelines that have been put in place. I forever remember how, when I went in the area, I found that the bulk water pipelines were lying beside the road. Those pipelines have now been installed, and they span a distance of 325 kilometers from the Nandoni Dam and into the villages in Guyana. A number of villages now have water. It's 90% complete. You're absolutely right when you say there are still challenges. There are still challenges.
Order, Speaker, please. Point of order.
Sorry, Mr. President, you can take your seat. Honorable Member, what's your point of order?
My point of order, can me and President will go check Guyana? It's totally wrong. We are misleading him.
Honorable Member.
It's not the truth.
Honorable Member, can you please switch off your mic? That is not the point of order. That is not a point of order. If you have got a substantive motion, you know in terms of your rules that you must table it. So you mustn't raise what is not a point of order. Thank you very much, Honorable President. Who's rising on a point of order? Mr. President, you can continue with the answer. There is nobody.
Honorable Penny. Na stiva ku ri ndhawu liya ma yi tiva a ni tivi ku ri mi huma kona na loko mi nga humi kona ni nga famba na n'wina hi ya languta ku ri ku endleka yini na hi ku loko ntirho loyi ni vulavulaka ku hi wona loko wu nga endliwi hi ta endla sure ku ri lava a va nga endli ntirho wa vona va ta huma hi va vekela a handle. But Honorable Speaker, what I was saying is that yes, I have been there myself and I've seen how in the past the pipes that were from Nandoni to Giani had not been installed. And I've spoken to some of the engineers, young men who are very capable, who were doing the work and making a great deal of progress. And so I am certain that the Giani challenge is being attended to and is also being completed. Now, 23 of the 24 villages now have reticulated and household connections. Now, obviously, it's all very well to say they have connections, but if the water is not flowing, then that is a problem. So that is the progress that has been made. After many years of corruption, many years of that project having lied fallow, we have now moved on and the bulk water system is in place, and in the end, the pipes are also being reticulated to now those villages. And there's a phase 2A, 15 villages that are also going to be connected. So the remaining work is being done, and of course, because it's a major project, it will be done to proper completion. With regard to ensuring that we move on with implementing what we have said about water and also ensuring accountability. Yes, there will be accountability for those who fail to implement or to do the work that they are meant to do. There will be accountability because, for instance, in Johannesburg, and indeed in many other places, we do want people to live up to what has been agreed to and what they have also committed. So we will ensure that there is accountability. Thank you, Honorable Speaker.
Thank you, Honorable President. Ms. Honorable S.L. Titebe.
Thank you, President. You are renowned for your orientation towards systems and institutions with regards to matters of governance and the aftermath of the Nugent Commission and the Phoenix-esque rise of SARS bears testimony to that. With regards to eThekwini, we have begun to see the results. Similarly, Mr. President, is it your intention that similar results will be achieved with regards to Johannesburg, but most importantly, the rising debt of the water boards, which pose a serious risk to water reliability, not only in municipalities that owe huge debts to water boards, but across the country? Will the President intervene to ensure that that situation is stabilized? Thank you.
Honorable President.
They won't make you minister.
Order, honorable members. Can we please order? Order, Mr. President.
Yes, thank you so much. I hear a lot of noise when you referred to...
Madam Speaker, on a point of order.
Honorable members, can I ask once again, if you want to raise a point of order, raise your hand, don't open the mic. No, I
Madam
see
Speaker.
Honorable Pambo, what's your point of order?
No, Madam Speaker, I'm just saying that can we keep the decorum? It's not time for auditions. Please.
That is
The
not a
cabinet
point
is
of
made,
order.
it's done. There's no need for auditions.
Honorable member, that's not a point of order. I think those of you who might know who's going for auditions, you can finish that debate outside. Order, Honorable President.
Madam Speaker, I can say that I'm not doing any audition. I'm answering questions. I heard a bit of noise when you referred to eThekwini. Seemingly there are people who almost deny the progress that is being made. And I'd like to invite those who are doubtful to come with me to eThekwini. No, come with me to interact with
Order, honorable members. You can accept or decline the invitation. The invitation is made. Mr. President, you can continue.
Date and time, Mr. President. Date and time.
Order, honorable members. I have asked the President to respond.
You can come with me so that we can go and meet business people, trade unionists, traditional leaders, religious leaders, community leaders, officials in local government, officials including the Premier at provincial level, and ministers who are also engaged in the work that we're doing in eThekwini. I say so because I think you need to hear their testimony. You need to hear how the private sector is now saying eThekwini is now a destination for investment. Not only local investors, but international investors. Water is being addressed and is beginning to flow. The roads are being repaired. The highways and the bridges are being repaired. And in fact, the surroundings of eThekwini could possibly be the biggest infrastructure involvement that we have in the country at the moment. So much is happening there. Yes, I have always had this approach that we should have proper systems, because the systems will then enable us to embark on processes that will deliver what our people want. But that must be coupled with having good people. So for me, it's systems, people, and processes. Once you have those three, you are then able to move forward. In the main, what we've been seeking to do is to recalibrate our systems. And in eThekwini, we've done that to a large extent. You referred to SARS and indeed to many other institutions as well, but more directly to Johannesburg. Johannesburg also needs a recalibration of its systems so that it is able to embark on all those processes that will serve our people better. And in the end, we need the people who are dedicated, who are there to serve the people and not to serve themselves. So if we can get those three in order, everything will then fall in place. So that is exactly what we are seeking to do in Johannesburg, and I have no doubt that we will achieve that. Because if the system works, the process leads to execution. And if the people are not fit for purpose, then they should be removed, so that people who are fit for purpose must then work within the system and embark on those processes that needs to lead to good delivery for our people. Thank you, Honorable Speaker.
Thank you, President. Honorable Maimane.
Madume President,
At the height of load shedding, we took your government to court and won. And at the height of this water crisis, we will do the same. Mr. President, you've got now over 10 people who are working on this water crisis. Let me list them for you. You've got a task team, you've got a presidential working group, you've got the Minister of Water, you've got the Deputy President leading a process. You go to Gauteng, the Premier of Gauteng is also involved. You've got the Water Board, you've got the CEO of the Water Board, you've got the Minister of Finance, as you've spoken today. You've also got the Mayor of Johannesburg, the MEC for Water and Infrastructure in Johannesburg. So, Mr. President, it's now over 10 people. My question is a simple one. If the people of Johannesburg do not have water by the end of the year, who exactly are you going to fire? Thank you.
Thank you, Honorable President.
Honorable Speaker, I missed the last part of the question. Who exactly am I going to do what to?
Mr. President, if the people of Johannesburg do not have water at the end of the year, who exactly are you going to fire if there's no water?
Well, simple answer to that, Honorable Maimani. As I said, we're putting the system in place and recalibrating it and the process, and then appoint and have the right people. If those people who are there are not going to be able to execute the processes that the National Water Crisis Committee comes up with, and of course, they will have to move out of the way. And they will be moved out of the way because what comes first are the interests of the people of South Africa and Johannesburg. So the National Water Crisis Committee is going to be overseeing all that and making sure that the job gets done. And if it is not done, then obviously heads must fall. Those who don't do their work will be moved out of their places. Thank you.
Thank you, Honorable S.J. Moore.
Thank you, Mr. President. But, Mr. President, your Water Crisis Committee has not met. You did not commit to ring fencing, nor decry Johannesburg's sweeping policy, taking critical funding away from Johannesburg Water. There are no criminal charges against corrupt municipal officials in the pipeline. The Deputy President's Water Task Team has failed. You speak only of things to come, plans, proposals, accountability. A month is a long time in a crisis, Mr. President, and many have been without secure water for years. With millions of South Africans suffering, are your SONA commitments not another failed promise? Thank you.
Thank you, Honorable President.
You know, when we set up NECOM, which is the National Electricity Crisis Committee, there were people who spoke just like you, who dismissed it, who fobbed it off and said it's going to amount to nothing. So I'm accustomed to that. People often want us to resolve problems and crises without approaching them in a systematic way. They always want us to rush in like a bull and knock everything out of place. What we tend to do, and this is precisely what I'm trying to explain here, we want to look at how we solve the system and enable the system to be able to stand on its own, to have credibility and efficacy, so that that system is then able to stand at the test of time and be able to enhance processes that need to be embarked upon, whereafter the people that we then bring in are then able to act according to system, are able to execute the processes. So, with regard to Johannesburg, now obviously you would want me as president to act as a policemen investigate, find wrong, charge the people, take them to court, prosecute them, and then judge them. I've said many a times here, I do not work that way, and the Constitution of your country does not allow me to do that. So we work according to the processes that are clearly laid out in our Constitution. Now, yes, you can bemoan the fact that the meeting has not taken place. I have taken trouble, Honorable Member, to say meetings have been taking place to prepare for the head meeting that is going to take place on Wednesday. The Deputy President has been working on the water issue diligently, and together with all others, he is going to bring together, we're going to bring together all the initiatives and efforts that have been put in place to make sure that this is not a bad promise. It's going to be as good a promise as we promised with electricity reform that is now underway, where we got rid of load shedding. So it will happen. Stand by and watch this space. Thank you very much.
Thank you very much, President. Honorable members, I just want to advise you that we are not doing well on time. You know that this process of questions to the President is allocated 3 hours. So I'm just asking us to make sure that we do not have spurious point of order that tend to delay us. We now move to the third question, which has been asked by Mrs. SMN Mokoena Zondi, who is the Chief Whip of the MK Party. The question is whether he has found that the National Development Plan clear targets of 6% unemployment, 5% economic growth, and a capable state by 2030 are out of reach under his presidency, as unemployment in its expanded definition is entrenched at 42%, growth at below 1%, and inequality at 0.67, which is worse than during apartheid. If not, what is the position in this regard? If so, what are the relevant details? Whether the government's medium-term development plan contains quantified, time-bound, and fully budgeted interventions that place the Republic on a credible trajectory to meet the NDP's 2030 targets. If not, how does the omission comply with his constitutional obligation under Section 83, subsection B of the Constitution of 1996? If so, what binding performance agreements with measurable indicators have been concluded with the relevant ministers? Mr. President, it's quite a weighty question, very long. I hope you will manage, and we'll all manage within time on supplementary question. Over to you. Thank you.
Thank you, Honorable Speaker. Quite not only a weighty but mouthful type of question. In September 2023, the National Planning Commission released its 10th 10-year review of the National Development Plan. Now, in that review, the NPC found that the targets relating to the elimination of poverty and reduction of inequality and unemployment will not be met by 2030. This was made public, and we should all know that we are indeed off target, just like many countries around the world. When it comes to the Sustainable Development Goals of the United Nations, it was reported at the UN that many countries are off target. In fact, the whole world seems to be off target. Now, while progress has been made on other NDP targets, such as access to education, health, water, electricity, and social assistance, South Africa remains highly unequal, marked by wealth disparities that span generations. The review by the National Planning Commission found several reasons for the lack of progress. Some of these factors that were highlighted by the NPC were external. The effects of the global financial crisis of 2808 continued to be felt in the South African economy for several years, much as we did not feel them immediately, but the aftermath was felt. The COVID-19 pandemic caused severe economic contraction in our economy. In fact, the biggest contraction our economy has ever suffered was suffered during COVID, where within a very short space of time, we lost 2 million jobs. Now, some of those jobs have not been regained, those that were lost during COVID. The years following the adoption of the NDP were the years of state capture, in which billions of rands were siphoned out of the state critical institutions when they were repurposed to serve the corrupt and also those who were there to plunder. The state-owned enterprises on which our economy depends, such as Eskom and Transnet, were stripped of funds, of skills and capable leadership. The economy was also held back by nearly 15 years of insecure electricity supply and the declining performance of our ports and harbors and railways. There have been broader challenges around the declining capacity of the state, particularly at local government level, a decline in fixed investment and poor coordination across the state. The investment in infrastructure just tapered down. The medium-term development plan has been developed to address these many challenges, but more importantly, to put the country back on track to realize the objectives that were outlined in the NDP. Now, the medium-term development plan aims to drive inclusive growth and job creation through structural reforms that we have embarked upon, which are already showing a great deal of benefit, as well as massive investment in energy, which we are already doing, pouring billions into our energy infrastructure, the logistics and water infrastructure, which we are attending to. It is focused on encouraging investment and creating employment in various sectors of our economy, like mining, tourism, the green economy, while also providing small and medium enterprises greater opportunities and funding as well. The MTDP has prioritized the reduction of poverty, as well as the high cost of living that beset South African families. We've also sought to expand the social protection programs and improve healthcare, better foundational education, and focus on skills development. Now, to ensure the success of such efforts, the medium-term development plan focuses on building a capable state, a state that is ethical and developmental in outlook. This includes professionalizing the public service, strengthening law enforcement, improving local government delivery, and rooting out corruption. Now, on a visit to Brazil just a few days ago, one of the things that we learned on how they've professionalized their public service is to require that people who want to join the public service should write an exam, should write exams which, if they pass, will then make them more eligible to get into the public service. It is a matter that I would like us to consider when we have to professionalize the public service, with a view of enhancing the capability of the state. The medium-term development plan contains a results framework which quantifies the outcomes, the strategic interventions, and which also provides us with indicators and targets to be achieved over the 5-year term that we have embarked upon. So the targets will inform the development of the work that we are doing. They are also reflected in the annual performance plans of departments and ministers have signed agreements with me, and we focus on how their departments are going to implement the medium-term development plan. So with all this, I am sure that we will be able, as we implement the MTDP rather, and the work that has been already underway, to steadily rebuild our economy and restore the capability of the state so that we can accelerate the progress that we already see happening towards the achievement of the National Development Goals. We are making progress. We have in large measure arrested the decline that was happening broadly in the economy as well as in government institutions. And I do believe that much as it's still a very early stage, that we're beginning a process of an upward trajectory. And we need to keep at it. And I've often said that we need all stakeholders, all hands on deck, including the doubters, including those in the opposition parties. All of us as a nation must put our hands together and move South Africa forward towards achieving the goals of the NDP. Thank you, Honorable Speaker.
Thank you, President. Honorable Dr. M.J. Becker.
Madam Speaker, one would have to be completely...
My apologies, Dr. Becker. I'm sorry. The first supplementary question is to Chief Whip of the MK Party. Sorry about that.
Sorry.
Thank you. President, the NDP was adopted as South Africa's long-term blueprint to drive economic growth as well as reduce unemployment and to build a capable developmental state by 2030. And despite what you say today, the reality facing South Africans tells a very different story. Economic growth has slowed dramatically, unemployment has risen, and the capacity of the state to implement policies continues to weaken. This then suggests that the problem may not lie with the plan itself, but rather with the leadership and the implementation by the executive tasked with delivering these targets. My question, therefore, is, do you accept that the widening gap between the NDP targets and the current economic reality reflects a failure of your leadership within your administration, and what consequences, including yourself as a head of state and head of the executive, should follow when those entrusted in implementing the plan fail to deliver time and time again? Thank you.
Thank you, Honorable President.
As I said, the National Planning Commission did say that we are off target, and I accept that. And I even gave you a global outlook of how various countries and governments have also been at work trying to live up to the United Nations Sustainable Development Plans. Now, in an ideal world, we should have moved much further, and we should have been looking at a situation where the NDP targets are within reach. They are not within reach. And I've outlined to you the various factors that have brought us where we are. And these are factors which, if one looks at them objectively, will find that they have a number of owners, entities, people, leaders who were supposed to do what needed to be done, not to take South Africa back. And of course, some of the factors are external. They are not those that we made or shaped for ourselves. But in the end, we need to collectively accept that we are off target. We now need to make sure that we correct course. And what we are doing is to correct course. If we were not correcting course, if we were not going back to the course of executing those targets, I would say yes, we should accept that we have dismally failed. What we are involved in is to correct course and to bring us back in line as a country, as many other countries in the world are doing, to bring everything back to enable all key stakeholders to work together so that we can achieve the objectives of the NDP. Now, as I said, there are quite a number of areas where we've made great success, and I enumerated them. However, I must say on the key ones, particularly the triple challenge, unemployment, poverty, and inequality, much as there's been movement forward, it has not been sufficient to satisfy the needs of our people. But what I would say is hopeful is that work is being done. We are continuing to build a capable state. We are continuing to address the issue of unemployment which has to be addressed by all parties, by the public sector, by the private sector, and we are increasing infrastructure build in our country, and we are attracting investment so that more and more people can be employed. And we're doing everything to ensure that the needs of our people at the social level are also addressed when it comes to health, when it comes to education, and when it comes just to their basic livelihood of making things like electricity and water available. So a combination of what we are doing tells us, or should tell us, that we are moving forward rather than static at a particular place. Thank you, Honorable Speaker.
Thank you, Honorable Dr. M.J. Becker.
Madam Speaker, I'm tempted to say my last question was left as incomplete as the largest party's execution of the NDP. In fact, one would have to be completely divorced from data and reality to believe that the decades-old goals for 2023 are still attainable. It might even stand now for not darn possible. If we promise not to blue tick you, is it not now time, Mr. President, to abandon the unexecuted NDP and, together with your largest coalition partner, drive a new economic deal?
Honorable President.
Honorable Speaker, I don't know how, having had this Parliament adopting the NDP, we just abandon it. I mean, you can abandon the name, but the substance of the NDP is about the life of the people of South Africa. It is about improving their lives, ensuring that there is economic growth. How do we abandon the concept of economic growth? It is embedded in the NDP. How do we abandon the objective of creating jobs? It is in the NDP. How do we abandon improving education and skills? That is set out in the NDP. So I do think that what the honorable member is saying is in the end not implementable. What needs to be implemented is to bring us back on course. I have referred to the global framework. There's the Sustainable Development Goals. The fact that many countries in the world, including your big economies, have not been able to live up to the Sustainable Development Goals adopted by the United Nations, they have never concluded that we should abandon them. They have actually said we must reinvigorate ourselves to ensure that we achieve the goals of the Sustainable Development Goals. And if you like, much of what is set out in the Sustainable Development Goals is what we have also embraced in our National Development Plan. So I don't see how we abandon something that from an objective point of view is good. And if we did, what would we aim for? Maybe the member will care, maybe he can't do it now, to sit down with me and outline to me those things that we should abandon in the NDP and what plan he has. I'm forever willing to listen and to listen to good advice. So if the member has good advice, I'll be willing to sit down with that member. They must come with their plan and the NDP and say, abandon the NDP, take my plan. I will listen, but I don't promise to adopt.
Thank you, President. Honorable N.M. Hadebe.
Thank you, Madam Speaker. Honorable President, you may have partly touched on the following, but given the widening gap between the NDP's objectives and current socio-economic indicators, has the Honorable President considered initiating a formal review of the implementation framework of the NDP to ensure that it remains a credible and actionable blueprint for inclusive growth, job creation, and state capacity? And what role will Parliament and departments play to rethink the strategy and restore confidence in the Republic's long-term development trajectory? I thank you.
Thank you, Honorable President.
Thank you, Honorable Speaker. Yes, there is a monthly review of the National Development Plan. And in fact, many departments, as well as what you could call analysts, argue that a regular monitoring process is essential for a long-term plan like the NDP, that we need to track exactly how we are going ahead to implement the NDP. And who should do that? The presidency should do it, the National Planning Commission should do it, and they do it. And the various cabinet clusters should also do it, and at the lower level, provinces and municipalities. So I want to accept that as a very good suggestion and say yes, so that we just don't do it at one level only. It should be done at all levels. Various departments, various entities should be able to examine the extent to which they are implementing on a monthly basis the implementation of the NDP, but more particularly of the medium-term development plan against the canvas of the broader canvas of the National Development Plan. We should, on an ongoing basis, be able to look at the economic indicators that Stats South Africa does for us, and we also do look at it from a trade and industry point of view, exactly what sectors need more attention and more support. And of course, we also need to look at, and the Department of Basic Education, we need to look at education as well as the Department of Higher Education. They do look at what is happening in our schools, and to funnel it all towards the NDP monitoring is a good idea, which obviously we will act on. But more broadly, I want to give honorable member assurance that yes, we do track the implementation of the NDP. Otherwise, if we didn't do that, it would be a dead instrument and a dead plan. So thank you very much for bringing that up to enable us to jack up, if you like, to use a colloquial term, the review system of the National Development Plan. Thank you so much.
Thank you, President. Honorable NLS Nkwankwa.
President, perhaps into Kala funeka uke upapashe as our performance appraisals or agreements as ministers sizokwazi ubhaqa abavela voco vuka kuvuthiwe babangele ninga-achieve i-targets. While there has been some progress through Operation Vulindlela in addressing structural bottlenecks in areas such as energy, spectrum, and logistics, South Africa continues to face persistently high unemployment and poverty despite multiple development strategies. The new growth path, President, which many people have forgotten about, also sought to drive export-led growth and labor-absorbing development strategies, but never gained traction. Countries like Vietnam, South Korea successfully combined the structural reforms you see in Operation Vulindlela, as well as regulatory efficiency and export-led industrial policies to achieve strong growth creation and to fight unemployment.
Honourable Member,
Given
your
this,
time is up.
I sawubuza, what structural
Order,
reforms are you
Honourable Member,
going
your
to
time
undertake,
is up.
President, to make sure that the medium-term development strategy
Mr.
is
President.
achieved? Otherwise, kaloku preamble ihamba yodwa.
Order, honourable members, I want to remind you once again, let's not have long preambles to the question because you do not have enough enough time for your question. Honourable President.
Yes. I mean, obviously, our economy has faced enormous challenges. Challenges of low growth, and that is why, over time, we came up with a number of strategies. Strategies which, if you look at, and you look at the National Development Plan, you all see that all they have sought to do is to embolden the National Development Plan. The National Development Plan is our marquee, our lodestar plan that all our efforts, including the current medium-term development plan, is pivoted on. We are seeking to achieve what we set out in the NDP, as we are seeking to achieve what we set out, what the world set out in the Sustainable Development Goals. Along the way, we've faced headwinds. Headwinds were, for instance, our economy was not growing at an appreciable level. And for years, our economy's growth was lackluster. And there are quite a number of reasons for that, and I've alluded to some of them. And of course, another reason is that the huge concentration of our economy is another reason that one can cite. But the low participation of the medium, small enterprises that face enormous problems like lack of finance, lack of the skills and market access is another. So we are addressing all that. And as we address that, we know that we will be able to generate growth. If Operation Vulindlela has shown us that when we focus on a particular problem, we do make progress. And similarly, that's the progress that we are making. You spoke about the growth plan that we once adopted. It is still part of what we are seeking to do. And as we open up new markets for exports, to be able to export goods to other countries, we are basing it on that. Right now, in the visit to Brazil, President Lula da Silva and I bemoaned the fact that we are exporting very little that we make between the two of the countries. And the trade imbalance is quite good, it's quite huge. They have a surplus and we have a deficit, but the trading has been very flat over many years. So we felt that we should reinvigorate it and get proper agreements signed so that the traders can begin to trade. And we agreed that as traders or merchants follow the flag, we must make sure that we install both flags, figuratively, Brazilian and South African, in our two respective countries, so that traders can then follow those flags, particularly through agreements that we will arrive at. We signed 2 agreements. There are many more that we need to sign to boost trade between our two countries, and will be doing so with many other countries to come. Thank you, Honorable Speaker.
Thank you, President. Honorable Mkwena Zondi.
Thank you, President. We hear you about Brazil and agreements, but if the country is truly getting back on its course, as you claim, can you point us to just 3 NDP targets that your administration is currently on track in achieving, particularly when it comes to economic growth as well as unemployment? Thank you.
Thank you, Honorable President.
Well, for starters, on economic growth, and when we look at progress, we need to look at progress in totality. Yes, it's always tempting to look at the economy, but we also need to look at the livelihoods of people, because in the end, we have to have an impact on the livelihoods of people. We are now spending about 61% of our expenditure on making sure that our people at a social level are able to live a lot better than they did in the past. So 61% of a budget of 2.2 trillion is phenomenal. Let's start there. Having done so, we have decided that we're going to spend R1 trillion in the medium term, just on infrastructure, because we continue to say that infrastructure is the flywheel that moves the economy forward. And as we do that, we are focusing on those network industries that drive the economy, like our roads, like our railways, like our logistics, the ports and the harbors. We're focusing on that, electricity as well as water. Now, all those are enablers that will enable our country to move forward. As we go around on our visits, we meet a number of people, both local and offshore, who are quite excited about the progress that we're making and want to come and invest. We're going to have an investment conference at the end of this month where we're hoping that we will reach our target of 2 trillion over the medium term. So we are doing a great deal after years of being stagnant and moving backwards. So we're moving forward, and there's a lot that is being done. And of course, what we also need to focus on is reducing the cost of living of our people. And as we do all these reforms, there's more capacity and more leeway to even bring the inflation down, making the cost of food and other commodities that our people need to come down. And what should follow then is interest rates should also taper down so that investors and business people can borrow money cheaply and invest, and therefore creating more and more jobs. So things are underway. We are not stuck in one place. Thank you, Honorable Speaker.
Thank you, Honourable President. The next question is question number 4 and has been asked by the Honourable Mkhize. The question is, while there are serious advances that the government has made since 1994 in relation to traditional leaders in the Republic, there is still more to be done. What steps has the government taken to ensure that traditional leaders are positioned legally to play a role in government programs, such as the Service Delivery War Room and municipal councils? The Honourable President.
Honourable Deputy Speaker and honourable members, while significant progress has really been made since 1994 in affirming and recognizing the role of traditional and Khoisan leaders in our democratic system, more work remains to ensure that traditional leaders and Khoisan leaders are fully integrated into our governance system, and they are seen as partners in development and governance. What is good is that our traditional leaders have actually themselves started and decided that they want to focus on development, so that the areas that they rule in should no longer be dormitories where they provide work to the urban areas. They want to be those areas to be economic hubs of one sort of economic activity or another. Now, through the district development model that we have, traditional and Khoisan leaders are recognized as core governance partners through this DDM process. The recognition of the role played by traditional and Khoisan leaders in the district development model represents a step towards more inclusive as well as effective governance in our country, fostering what I can call partnerships that enhance community engagement as well as development outcomes. In addition, a comprehensive legal framework exists to give effect to the participation of traditional leaders in municipal governance. Now, where traditional leaders participate in local governance, we find that great progress can be made. The Traditional and Khoisan Leadership Act makes provision for traditional councils to support municipalities in identifying community needs. Now, under the Act, local houses of traditional and Khoisan leaders may participate in municipal programs, and in some areas they do, strengthening accountability at local government level. Now, the Municipal Systems Act requires municipalities to consult traditional leaders in development issues, in the development also of the IDP, the Integrated Development Plan. The Municipal Structures Act provides for recognized senior traditional leaders and Khoisan leaders to participate in municipal councils as ex officio and advisory members. And where this is done, it works very well. This includes the authority to participate in council meetings, to address the council on matters affecting traditional or Khoisan communities, and to participate in policy, bylaws, and service delivery discussions. And this is how the partnership between traditional leaders as well as local government councillors becomes really, really useful. Now, while the framework is robust, implementation across municipalities remains uneven. Now, to address this, the medium-term development plan now includes a very specific indicator for the participation of traditional leaders in planning, implementing, and monitoring government programs. Now, this is a great advance forward. The Department of Cooperative Governance and Traditional Affairs has commenced capacity building in district and metropolitan municipalities to strengthen the compliance with the provisions that are relevant to our laws. Now, these interventions are improving institutional as well as reinforcing integration of traditional leaders into governance and service delivery. The review of the white paper on local government that is currently underway proposes a much more structured cooperation between municipalities and traditional leaders so that the problem-solving effect can be achieved. The government remains firmly committed in ensuring that the institution of traditional leaders is recognized, is empowered, is strengthened, and integrated into our governance system. Now, their wisdom their legitimacy and proximity to communities is indispensable to building a capable and state and improving service delivery for our people more broadly. So the role of traditional leaders is being enhanced, and we've made tremendous progress since 1994 to give effect to ensuring that we have a government of the people, by the people. Thank you, Honorable Deputy Speaker.
The first supplementary question will be asked by the Honourable Mkhize.
Thank you very much, Deputy Speaker. Thank you, Mr. President, for the response. There are rising concerns from traditional leaders with regards to their roles, powers, and responsibilities, as well as Khoisan communities in relation to their traditional structures, traditional leadership structures. In the light of the response by the President and considering the current preparations for the tabling of the National Traditional Khoisan Leadership Bill, would the President consider encouraging the Minister of the Cooperative Governance Traditional Affairs to fast-track the consultations to address the issues raised of formalizing the current roles, powers, and responsibilities of traditional leaders and the structures of the Khoisan community leadership as partners in service delivery? Thank you.
The Honourable President.
Thank you, Deputy Speaker. Absolutely yes. The Minister is quite committed to not only to enhance the role of traditional and Khoisan leaders, but to ensure that they do participate in issues of service delivery. And as I said in my head reply, traditional leaders are not only leaders of our people when it comes to culture, when it comes to tradition, they are also the leaders of our people when it comes to their well-being, when it comes to service delivery. And they should participate because they are closest to our people. And so therefore, due consideration needs to be given to their views, to their participation, as well as to their wisdom. And so therefore, what you're proposing, Honorable Mkhize, is precisely what Minister of Cooperative Governance and Traditional Leaders will be doing. He is oriented in that way anyway, and he will be focusing his attention on ensuring that we do live up to what we say. I personally believe that the participation of traditional leaders in enhancing governance at the local level is absolutely essential. We cannot do the enhancing and strengthening of government at local level without the role of our traditional leaders. So they do need to be given the respect, the role, and the recognition, as well as the active participation in those councils. And where these processes are weak, we need to strengthen them to make sure that indeed that role that traditional leaders should have is actually in place. So thank you once again for raising the issue. Thank you, Deputy Speaker.
The second supplementary question will be asked by the Honourable Labuskaghni.
Mr. President, traditional leaders participate in municipal councils in terms of our governance framework. Thank you for the broad outlay that you gave on how they can contribute and how they should add value to the functioning and accountability of these councils. In your view, should they also play a role in encouraging residents occupying land under traditional authority to contribute to municipal sustainability by paying the required taxes and rates and taxes? that fund service delivery? Thank you.
The Honourable President.
Thank you, Honourable Deputy Speaker. Of course, all of us who are required to pay our rates and taxes must do so. And I know that there are temptations in certain parts of our country for certain of our residents to try and escape the payment of rates and taxes. It is essential that all of us should do so. And indeed, traditional leaders should be called upon to encourage our citizens to pay rates and taxes, because it is the services that are delivered to our people that need to be paid for. And where, for instance, there is poverty, where there is indigent residents, we have at the national government level embarked, or we've provided a facility and an intervention to support indigent households, those who cannot pay. And it's quite a substantial budget. We do want our local government structures to make sure that they have a proper register of indigent families, so that when the money has to be accounted for, it is properly accounted for. And that when the grant is given by national government, it actually goes to the assistance of our people and not just to the payment of salaries of those who are employed. So the answer to your question is yes, very much so. Thank you, Honourable Deputy Speaker.
The third supplementary question will be asked by the Honourable Zet Mtetwa.
President, this day marks 5 years since the death of the great Zulu king, who topped 50 years of his jubilee on the throne. And posthumously, we would have asked you this question. Given that the constitutional framework after 1994 entrenched Section 25 protection for existing property relations arising from colonial dispossession, while institutions such as the Ingonyama Trust administer millions of hectares of land under the custodianship of Amakosi, why has government vested decisive authority over land use, development, and service delivery in municipalities rather than empowering traditional leaders to make binding decisions over land under their jurisdiction? And will your government now introduce reforms to restore meaningful decisive decision-making powers? Thank you.
The Honourable President.
I failed to pick up the question. Yes, please.
It's the English. The question is, the Constitution does not give Amakosi powers to make decisions in their jurisdiction. Instead, that power is given to local municipalities, but these two institutions are recognized by the Constitution. So will you change the Constitution to allow Amakosi to also make decisions at the municipal level?
Mr. President.
Well, the constitutional provision is a matter that you as members of parliament should deal with. However, we are currently involved in a fairly intense, not intense, but a very substantial process of discussing with our traditional leaders and their various organizations how we should deal with communal land, the land that resides where they rule. So that is a discussion that is underway. I should say that it's organizations like Contralesa and others who have raised this issue prominently, and we are dealing with it and will find clear solutions in time. So the discussions are ongoing. We will be ensuring that we reach a conclusion. Now, obviously, you compare traditional leaders and local government. Now, when local government and local government is in charge of land that is owned by the government as a whole, land is owned by local government
on behalf of government at a local level. Land is owned by provincial on behalf of the government and national on behalf of the government. So they are then able and empowered to deal with, say, the ownership of land and transfer for the benefit of the people as a whole. And whatever transaction they arrive at goes into the people's pot, as it were. It goes into the local government revenue savings. And therefore, we need to look at how we deal then with the issue of communal land. How do we deal with it? In some instances, I should say, there are traditional leaders who have tended to say, this is my land, I will sell it to you, and it's said that some of the money finally does not go into the traditional pot, it goes into another. So those are issues that we need to discuss, and we are actively discussing those issues with our traditional leaders, because there are matters that need to be talked about. There are matters that need to be discussed, so that as we build the nation, we are able to do it to the benefit of all. So, Honorable Deputy Speaker, this matter is being addressed, is being attended to. Thank you.
The fourth supplementary question will be asked by the Honourable Van Wyk.
House Chair, President, I just want to thank you yet again for deploying the army in Johannesburg, especially El Dorado Park and the surrounding area, President. Thank you very much. President, while significant progress has been made regarding the Koi and San leadership, especially since 2019, and also used advancements with the new seventh Parliament in 2024, a lot of challenges also still persist in the recognition process under the Commission of the Koi and San matters. What measures can be put in place, Mr. President, to expedite this process, allocate increased funding to the Commission, and also deploy more support staff to the Commission in order for them to execute their mandate, Mr. President? As nou al baie lank my grootman. Baie dankie.
The Honourable President.
Thank you, Honourable Member. You will have heard me say that the Department of Cooperative Governance and Traditional Leaders is involved in quite an intensive process of increasing the capacity of our traditional leaders and those that work with them. And this is aimed at, obviously, enhancing the capacity of the state and strengthening the capacity of the state. So those initiatives that manifest themselves in the holding of workshops, in the holding of mini conferences and all that, are aimed at achieving precisely the objective that you have articulated. We are aware that there is a need to increase the capacity of many who work with our traditional leaders. And you'll be pleased to know that even our younger traditional leaders do themselves participate in some of these initiatives because they see themselves gaining a great deal. And in the end, it will make the whole process of traditional leadership much more effective, and it will also modernize it in more ways than one. So we will be carrying on with that, and I'm glad you have raised it, and Minister of Cooperative Governance and Traditional Leaders has heard that very well as well. Thank you, Honourable Deputy Speaker.
The last supplementary question will be asked by the Honourable Mkhize.
Thank you very much, Deputy Speaker. Thank you, Mr. President, for your responses. The processing of this national traditional Khoisan leadership bill will be significantly impacted upon by the dynamics around the issues of powers and particularly the issues of the structures, leadership structures on the Khoi and the San communities. Would the President consider issuing a statement to reassure traditional leaders, Khoi and the San communities, of his approach in resolving these matters? Thank you, Mr. President.
The Honourable President.
The answer is yes. We will work on that, Honorable Dr. Mkhize, with the Minister to give that assurance. Because where there is doubt and where there is uncertainty, we need as government to respond, and we will do so. So the Minister of Kokta is here. We will put together a statement that will go out to our traditional leaders. Thank you very much. Thank you.
We now move on to question number 5, which has been asked by the Honourable Malema. The question is, considering the dire state of public health facilities that are characterized by chronic shortage of health professionals and overcrowding, what A, progress has the government made towards the full implementation of the National Health Insurance, and B, practical interventions he has made to ensure that when the NHI finally gets implemented, the country's health systems will be fully functional? The Honourable President.
Thank you, Honourable Deputy Speaker. The National Health Insurance is South Africa's way of implementing universal health coverage as decided upon by the World Health Organization and adopted unanimously by the United Nations General Assembly. It is important to put this across so that those who are opposed to the NHI should know that what we are seeking to do is not just a pipe dream. For our country, it emanates from what the Freedom Charter said, but more importantly now in governance, we have embraced and taken to heart what the WHO and the UN have decided. Since the assent of the National Health Insurance Act, the Department of Health has been busy with a whole range of preparatory work initiatives. This includes procedures for the registration of people who are going to use the NHI and the accreditation framework and the contracting arrangements for healthcare establishments and providers. We are also rolling out the digital systems that are required to trace a patient between different doctors or health centers, and also to provide service providers with knowledge or line of sight, as well as to ensure that this happens whether one is in the public sector or the private sector. Now, the digital systems include a health patient registration system that's directly linked to the Department of Home Affairs Population Register, as well as an electronic medical record that will roll out across more than 3,500 public healthcare facilities over the next 15 months. Practical interventions to improve the quality and accessibility of healthcare include significant investments in infrastructure, including rebuilding of old hospitals and building of some new hospitals, health centers, and clinics. Now, this is taking place alongside measures that we are taking to improve hospital governance as well. The national and provincial departments of health are also focusing on employment of doctors, other health professionals, and community health workers. The Minister of Finance stood here during the medium-term policy statement and said we are going to employ doctors, and we are in the process of doing precisely that. As government, we have agreed not to proclaim any sections of the NHI until the Constitutional Court has handed down its judgment in legal challenge due to be heard at the beginning of May 2026. Now, the challenge that will be heard by the court relates to the issue of public participation, which other litigants have taken us to court on. That led to the adoption of the NHI by Parliament. We made this undertaking to ensure that other legal challenges to the NHI, which includes whether the President should have signed the NHI or not, which have been brought on a number of other grounds, are managed in an orderly manner that does not cause prejudice to any party. Now, this undertaking, which has been made an order of court, will not affect the timetable for the implementation of the NHI, nor will it stop the work currently underway. Work has been going on, up to and including improving our infrastructure. Honorable member may want to remember that I said I visited George Mkhari Hospital, and I found really horrible conditions there. And indeed, there are many horrible conditions in many of our hospitals. Now, the work of either building new facilities, revamping those facilities to make them fully ready for the implementation of the NHI are ongoing. And there are a number of initiatives that have to be put in place. The NHI itself aims to establish a single national fund that will allow for the equitable purchasing of health services from the private and public healthcare centers. This will enable the whole population to access all the potential health resources in the country. Now, the changes brought about by the NHI are complex and far-reaching as well, and therefore need to be implemented on a phased basis, and that's precisely what we are doing now. As provided for in the transitional provisions of the Act, these measures need to be undertaken gradually on a phased basis, in a phased manner rather, using a progressive as well as programmatic approach, which is based on the availability, of course, of our financial resources. Now, in the end, we are determined to ensure that every South African has equal access to quality health care regardless of their ability to pay. And this is a commitment that we are not prepared to move away from. I thank you, Honorable Deputy Chairperson.
The first supplementary question will be asked by the Honourable Malema.
Thank you very much, Deputy Speaker, the President. Otwa.
Roto zavudi vutisa vone vashavi.
Hey, coffee sapa man.
Nne di chivona vashavi nditopfa ndotakala nga maanḓa.
Ndi haya. Nda. President, with all those complications of the NHI, the EFF once put a bill here in 2018 that let's open clinics for 24 hours. And unfortunately, the ANC rejected that. Our people cannot wait for postponement of the implementation of the NHI because they are sick now. They are not going to be sick in 2030. So we must be seen to be doing something now. Our people want clinics and health facilities that are in good condition. not a bread per house. Huh? People, instead of implementing what is going to change the lives of our people, they are buying them with bread and not implementing what is going to change the lives of our people. Now that, President, you have been exposed to this, and especially George Mukari and many other facilities, Chelizini and everywhere else, are you going to support a proposal of the EFF that says, let the clinics be opened 24 hours, let the clinics be serviced and renovated and improved while we're still working on this long term? You just said to yourself, it is in phases, it's complex, it's difficult. Worse, it has been taken to court. They can't take us to court for upgrading our own facilities. Some of them are there. So let's work on them now and make sure we improve the conditions and stop giving people bread in exchange for vote, but give them what will change their lives for better. Thanks very much.
The Honourable President.
Thank you, Honourable Deputy Speaker. Honourable Malema, you'll be pleased to know, maybe for the very first time, that I agree with you. Now, I think it's really ideal, and what you're articulating is what I've come across as I go around the country, particularly in the deep rural areas. People say we would like the clinics to remain open and on a 24-hour basis, because when our people are sick, where do they run to? They have to go to big cities and all that. I agree with that. Now, the issue is there must be personnel in those clinics. You've got to have nurses, and ideally you've got to have a doctor on standby. Now, yes, we can agree that ideally we want those clinics to be open. And I don't think, Honorable Malema, it even needs a law. It should not even need legislation. It should just require regulations from the Department of Health and how those regulations should be implemented. Because when you have a clinic open, you cannot have an empty building open. You must have those people or professionals who must serve. Now, this is where our challenge from a fiscal point of view is. We have not, and Minister of Finance dealt with the matter here in October, we have not been able to employ doctors, enough doctors. And wherever we go, we often meet young people who have said, you have invested a lot of money in me, in training me for 7 years and thereafter 2 years, but I don't get a job. And that is a fiscal challenge and problem, which we are in the process of resolving. So those clinics ideally should be open with nurses there and a doctor on standby, on call rather. So that is supported, and it's a process that will be implemented as we move on, as available resources become easily available for us to be able to pay them. There are quite a number of young people who say, I've wanted to be a nurse for a long time, but I see that there are no jobs that are open. So we therefore need to train those nurses, make them available, and have them in those clinics. So I agree with you, and without saying it's conditional, I would say that it's something that, as you have raised it prominently as well, that I would like us to attend to. And so, because this is such a positive parliament, positive National Assembly, it is something that will pass on to the minister so that we can look at it closely. So, upasitse proposal ya hao iamogetšwe, o ka kry-a le certificate. Thank you, Honourable Deputy Speaker.
The second supplementary question will be asked by the Honourable Mutambi.
Golibuwa mutusa muwenisi wa putano lino Dimasiari, President.
Masiari abuti.
You have rightfully noted that NHI is South Africa's vehicle for universal health coverage, ensuring that our people no longer suffer the catastrophic healthcare expenditure that normally sinks our families because of the huge costs. You also highlighted that a significant majority of specialists in our hospital are only currently saving a fraction of the people, especially in the private sector. Given these stark disparities, Mr. President, could you further profile for the nation in this House the transformative benefits the NHI Fund will bring to bridge this gap, such that to an extent that a sick child in a rural underserved
Honourable
village
Member.
like
Your time has
Hamudimeli
expired.
can also have access to good quality health care?
Yes.
The Honourable President.
Honorable Deputy Speaker, I would say, zwi fanela uri zwi vhe ralo. Ṅwana ane a lwala emahayani u fanela uri a kone u dzhena sibadela a yo ṱolwa nga dzi ṅanga dzo funzeaho vhukuma dza dzi specialist vha kone u mu ṱola vha kone u mu lafha. And hezwo zwithu, as you are saying, Honorable Member, it's only available, say, in the cities and private hospitals and all that. We want the NHI accessibility for healthcare to be widespread. Now, those who are opposed to the NHI are not alive to this reality, that there needs to be health equality in South Africa. We cannot have the majority of our population being relegated to the back to bad health care. We want all South Africans to have access to the best health care that the country can give. Now, you see, there's the other element to it. The government pays a lot of money training our doctors, training our specialists. And having trained them, I think it is a real abomination that they only become available to a small elite minority when they've been trained by the public sector and are not available to give health care, good quality health care and top-class health care to the majority of our people. And that is why NHI must be implemented. Our people must be able to walk into any health facility and require that they should be treated, yes, at no cost to themselves, because that is what we have committed to our people, and the Freedom Charter taught us that. And that is where we are going. Whether it is opposed or not, we will get to that objective of having health care available to our people as a whole. Thank you, Honorable Deputy Speaker.
The third supplementary question will be asked by the Honourable Leroux.
Thank you, Deputy Speaker. Mr. President, given the High Court's order suspending the implementation of national health insurance, and in the light of recent arrests of 3 of the Department of Health's most senior officials for alleged corruption, fraud and theft, we need concrete interventions to safeguard the NHI fund from the rampant corruption that has already plagued the public health sector. While we welcome the suspension of the Director General, the Chief Financial Officer and the Deputy Director General, South Africans want accountability, not just suspensions. Will the President urgently refer the governance and financial controls of the Department of Health, particularly those that will be in future linked to the NHI fund, to the Special Investigating Unit for a full investigation? Thank you.
The Honourable President.
Yes, we have taken action against those who are implicated, and obviously you would like that they should not just be suspended. There have been allegations have been made against them, and they have been arrested and charged, so we have suspended them. We now need to go through a process as required by our laws, as required by our regulations, to process those allegations through disciplinary processes so that there's fairness and equity, and thereafter a clear decision will be taken. So I have suspended the Director General, and the other officials have been dealt with by the Minister. So in the end, we do want to ensure that there is accountability by all officials and all people who will be dealing with the various aspects of implementation of the national health care. And this is precisely what we are exemplifying. We are saying accountability has to be the order of the day. If you are found to have done wrong, you must be put aside, you must be suspended, you must even be dismissed. Because what we are now saying is that if you are required to do a certain piece of work and you don't do it, you don't deserve to be there. So we will remove you, we will suspend you, and we will deal with you. That is an approach that we are not going to turn back on, and we are proceeding in that direction. And of course, as you deal with major processes like the NHI, there will be challenges that we will come across. Now, if the system is well structured and the processes need to be executed, if the people who are supposed to do so are not good, you get rid of them and you put people who will work according to the system and make sure that they implement processes that should be implemented. That's how we are going to approach the work that needs to be done in the National Health Insurance. Thank you, Deputy Speaker.
The fourth supplementary question will be asked by the Honourable Boshoff.
Thank you, Honourable Chair, Honourable Deputy Speaker, and Honourable President. I ask this on behalf of my colleague Van Staden. Mr. President, it is a fact that South Africa's public health facilities are in a poor state, some more than others. Particular concern is due to the institutions that have been earmarked as national health insurance pilot sites. One such example is the Chiledzini Regional Hospital in Thohoyandou, which was designated as an NHI pilot project. At one stage, however, this hospital was investigated by the South African Human Rights Commission for alleged human rights violations. The investigation is reportedly still ongoing, despite the hospital having been announced as an NHI pilot site. Can the President inform this House what criteria are used to designate the hospital as an NHI pilot project, particularly in a case where the hospital, at the time of announcement, due to significant operational challenges, did not operate as a fully functional facility?
The Honourable President.
Now, those sites that had been set aside for NHI, if you like, practice run, are centers, and there have been a number of them. A number of them have been very successful, and regrettably, there was the one that you spoke about where the Human Rights Commission found a number of challenges. What we can say is that there's been a lot of good that has come out of the implementation. I would call it the practice run, because the key objective of the NHI is to reduce inequality and to ensure that there's universal access. Now, those that we have run a practice on have shown the efficacy of the national health system that will be introduced, as we will introduce it gradually. And they've also shown the efficacy of strengthening the primary healthcare process and ensuring that in the end we build the systems, and those that we've put forward as test run clinics or health centers have been working on ensuring that the information process is well introduced. I went to one some few years ago, and I found deep in the townships of our country that it works extremely well. And it interfaces with our people. Those who have to come and get chronic medicine, they come on the day they are supposed to come through an appointment. There's no more queuing for medication that I saw at George Mukari Hospital. And that, for me, showed what the future looked like with regard to the implementation of the NHI. So the NHI, in the end, must never be a white elephant. It must be a system that will benefit our people as a whole. And those weaknesses that were identified in some of those test-run clinics or health centers is something that was good in that we identified weaknesses which we now need to strengthen. So it's been a good process. We are ready. We are truly ready for the NHI rollout. Thank you very much, Honorable Deputy Speaker.
The last supplementary question will be asked by the Honourable Malema.
Thanks, Chairperson. Deputy Speaker. President, ya o re nna le lena re kwana la mathomo batho ba mo South Africa ba tla makala ka gore o na le tše dintšhi tše re kwaneng ka tšona le tša go fitha le gana mo leemeng re kwana ka tšona yalo ele ka re mathomo re kwana ba re ba bona di thomile di-politician a di bolele nnete. President, I want a fiscal problem. Auditor General of South Africa says 406 billion is being spent on corruption and irregular spending. If you redirect that money, you give us the best health facilities. There is no shortage of human capital. Bana ba bo rena ba tletse di strata, di doctor di a matcha, ba apere di gown ba ra bana mebereko. And therefore, ever rena le fiscal problem ya ba patel. Eba ka mkhomo because chelete shi e gona. We need to stop corruption and redirect this money and invest in our proper public health system. So
Thank
one
you,
of the things we
Honourable
have put
Malema.
forward
Your
is the
time has
bill
expired.
on insourcing to deal with this problem. I hope the President will support us to pass a bill on insourcing of all government workers who are temporary workers. Thank
Honourable
you.
Malema. Honourable President.
Thank you, Honorable Malema. You know, I spoke about the problem of outsourcing. And when I heard you speak about it, I said, oh, Malema is agreeing with me now. The problem of outsourcing, which I think many of us, even in this parliament, have realized is a major problem that we need to reverse and to arrest rather. We've tended to, and arrest I think, we have tended to outsource so many functions that should belong in the hospital, functions that should belong in the department. I've even asked Minister of Health, Minister Akumput, if we have to buy tablets, Panado, why do we need to go to someone else? Or either regular Panado. When we know who makes Panado, that firm or entity must provide us with Panado. And if we have to do a tender or a procurement process, we can do it directly. And the minister answered and said, this is complex and all that. And I'd like to say that we need to outsource what government cannot do itself. Many functions we can do ourselves and cheaply and cost effectively. That is precisely what we now need to do. Now I have said, I've declared war on outsourcing. Let us insource as much as we possibly can in government. And you know the benefit of that is that it increases the capacity of government. It enables people to want to come and work in government, particularly young people. We train them to be experts, and then we leave them outside of government. We must train them to be experts to come and work in government and do the work that needs to be done in government. And this is now a growing phenomenon around the world. Many governments are realizing that insourcing is far better. There is a book written by Professor Mariana Mazzucato who reports that the US and the UK outsourced their functions during COVID, and they lost a lot of money. And yet, if they had insourced, like much of what we did here, they would not have. What we did do incorrectly, ourselves, to be critical of myself and us, is that we outsourced the acquisition of the personal PEPs. We outsourced that, and that resulted in major challenges of corruption in our country. And yet we did insource the vaccines. That we handled very well, because only government acquired vaccines and distributed them as it did through the various hospitals and clinics. So there's a great argument to be made for insourcing. Sometimes we find we insource even, the work that should be done in the garden. Me o cleanang o hirwa ke batho ba bang, a tlo clean, and then ha question the benefits. The benefits, and after 3 months, wa rakiwa. She's out of a job, and yet she's working for a government institution. We do need to give respect to our people by giving them decent jobs. Outsourcing does not result in decent jobs. Therefore, insourcing is the best way to go. Thank you, Deputy Speaker.
President, I've got a membership form for you.
Honourable members, we move on to the last question, which has been asked by the Honourable Radebe. The question is with reference to the announcement he made during the State of the Nation address on 12 February 2026 that the SA National Defence Force will be deployed to support the SA Police Service in efforts to address the illegal mining and gang violence in Gauteng and the Western Cape. What measurable outcomes and sustainable improvements in public safety in the provinces does he envisage by the deployment? The Honourable President.
Honourable Deputy Speaker, the South African National Defence Force is being deployed as a force multiplier to the South African Police Service to address a whole number of challenges we face: gangsterism in the Western Cape, in the Eastern Cape, and in Gauteng, and illicit mining in Gauteng and in the Northwest Province. The SANDF deployment is necessary to complement the efforts of the SAPS in tackling these crimes and bringing stability to our communities. So the Army will be deployed in support of the police, operating under police command with clear rules of engagement and for specific time-limited objectives. Now, the Army may, for example, be called by the police to provide protection in high-risk areas or operations, or to support cordon and search operations, roadblocks against armed criminals. Soldiers may also be used to secure critical infrastructure so that it can free the police to focus on investigations. Now, some have suggested that by deploying the police, it means that the police have failed. That is not the case. We are actually getting the police and the army to work together to handle the challenges that our people are facing now. The deployment of the army will take place alongside other measures, such as strengthening anti-gang units and also illegal mining task teams. The police will also be working with the National Prosecuting Authority to multidisciplinary tasks to target the leadership, the finance and arms of those who are getting involved in all these criminal acts and networks. Through this support, we aim to achieve a significant reduction in serious and violent crime across targeted areas of deployment, with a neutralization of gang violence and illicit mining. And that process is being implemented on a gradual basis as the Defense Force deploys in a number of areas. We've already seen how the Defense Force has been well welcomed in various areas where they are. Where they become present, there is stability, and obviously we want to instill that stability and rid our areas of criminality on a permanent basis. So we've deployed them for a specific time frame, and we will be able to determine precisely how long we should extend if the extension is necessary. But it's already working, and our people are now pleased. In the past, whenever the soldiers were deployed, it would drive a lot of fear in the hearts of our people, because the Defense Force or soldiers are trained just to shoot and kill. And this time round, we have developed our Defense Force capability so well. They build bridges. They save people who are in danger. They also help with supporting the police. So we now have a Defense Force, much as many people may be critical of them, a Defense Force that is well attuned to serving the people of South Africa, and they are already doing a fantastic job. During the 2021 unrest, we relied on the Defense Force, and they were able to help a great deal to quell down the instability that was being perpetrated. So this time around, we are focusing their involvement together with the police in certain high-risk areas, and I'm sure they will do well. Thank you, Deputy Speaker.
The first supplementary question will be asked by the Honourable Radebe.
Thank you, Madam Deputy Speaker. Thank you, President, for the response. The follow-up question is, in addition to targeting known hotspots in Gauteng and the Western Cape, what measures are being implemented to increase police visibility and presence in other vulnerable communities across the Republic, including specialized patrols, rapid response teams, and coordinated operations with provincial law enforcement to prevent the migration or resurgence of illegal mining and gang networks? Thank you.
The Honourable President.
Thank you, Honourable Speaker. Yes, Honourable Radebe, we are hoping that with the success they are going to achieve, we will be able to showcase and demonstrate that indeed they are as effective as we had said they would. There may well be other areas, and when we made the announcement here, it was the Eastern Cape which had been excluded, which immediately raised their own challenges, and we responded by saying we will include the Eastern Cape. So where the need arises, where there are hotspots, we will be able to be ready and willing, in fact, to approach Parliament, to inform Parliament, as I have already said, that I'm deploying the Defense Force in these areas, and for the time frame and what it will cost. So when that happens, we will be able to also approach Parliament and inform Parliament what we are seeking to do. So we will never deploy the Defense Force without your knowledge and without you being able to hold us accountable for whatever may happen in that regard. Thank you, Honorable Deputy Speaker.
The second supplementary question will be asked by the Honourable Muela.
Thank you very much, Deputy Speaker. Honorable the President, allow me to commend you for recognizing that the freedom and security of every South African demands a multi-layered, multi-force multiplier effect to deal decisively with crime and its underlying socio-economic causes. Will the Honorable President assure this House that in strengthening state capacity and fighting crime, government will be informed by this whole of society and whole of government approach? Thank you very much, President.
The Honourable President.
Yes, I'm able to give that assurance. Criminality is one of the key priorities that we are focusing on now. Obviously, jobs and reducing the cost of living and fighting criminality is a key area of focus, including increasing the capacity of the state. Now, through getting the Defense Force as well as the police to work together, intelligence is also involved, crime intelligence is involved, and also the NPA. Now, if you look at this entire architecture, it basically means that we are enhancing the functioning of the state. We are enhancing the capability of the state by getting all these entities that ordinarily would not easily work together. So we are meshing them together and they are working together, and we are already seeing good results coming out of that. And we are able to say, as we strengthen this whole process, we will be able to deal with criminality. And we have said that criminals must know that we are coming after them. And this deployment, and the deployment in itself also frees the hand of the police to do their investigation work. It frees the hand of criminal justice, criminal intelligence rather, to do its work. So through this, we will be able to show tremendous progress in fighting one of the biggest challenges. And of course, in the course of doing all this, we will also be focusing on technology. I have said very clearly to the security cluster that technology must be one of those enablers that enables us to make the country safe, communities safe, and areas where our people live safe, and safe for businesses to operate and create jobs. So a combination of all this is going to enhance our ability to deal with criminality. Thank you, Honourable Deputy Speaker.
The third supplementary question will be asked by the Honourable Schikkerling.
Thank you very much, Madam Deputy Speaker. Good afternoon, Mr. President. Mr. President, how can government claim to be fighting gangsterism with the SANDF while allegations suggest that individuals linked to your CR17 campaign and appointed to a PRASA task team have enabled a gang boss to access state contracts? And will you support suspensions of PRASA individuals, a full investigation, and the blacklisting of those implicated? Thank you.
The Honourable President.
As I have said, one of the key processes that we are involved in is to enhance accountability, to ensure that those who are found to be doing things that militate against the interests of our people should be made to be accountable. If you are doing wrong, you should account. You should subject yourself to processes of the law, and if you are identified in whatever position you are, you should be brought to book. And that is the assurance that I can give. Because as I said earlier, because the state is so big, and there are many actors in the state, and many of them tend to do things that are wayward or wrong, once we have a system that can identify wrongdoing, that is what we should rely on to make sure that we do deal with those who are deviant. Thank you, Honorable Deputy Speaker.
The fourth supplementary question will be asked by the Honourable Manyi.
Thank you, Deputy Speaker. President, the internal deployment of SANDF signals a failure in policing and intelligence systems. That's the first issue. Simple question. What measurable benchmarks will you be using to determine the stability that you spoke about? What are those measurable benchmarks? Will it be the arrest of the illegal mining kingpins? Will it be the dismantling of syndicates? Will it be the seizure of illicit proceeds? Will it be successful process? What exactly will it be? And lastly, what will be the exit strategy to ensure that military does not become permanent substitute for civilian policing? Thank you.
The Honourable President.
We will do all of the above that you have said. You'll be pleased to know that I agree with you as well. But also when it comes to the temptation, and it can never be a temptation for a permanent deployment of the soldiers, it can never be a temptation because it costs a lot of money. So they are a temporary intervention to help us to stabilize the situation and to free the hand of the police to act quickly, to act against those who are either involved in syndicates and doing all manner of things. So that is a temporary measure, and people have criticized and said, well, what then happens afterwards? Of course, we must rely on our other criminal justice agencies. Our security cluster must come forward itself, the police, criminal intelligence, and all those who are supposed to deal with the safety of South Africans and resolve those issues and address those issues. It is only when we see that they need support, and that is why we say they are a force multiplier, but more correctly, they are a force strengthener. They are strengthening the resolve of the police and the criminal intelligence and the NPA, if you like, to do the work that they should do. So I have confidence that after the Defense Force has been deployed, we will be able to have stabilized the situation. And of course, they may need to move to another area because criminals, for instance, tend to be sometimes one street ahead of us, but we want to catch them before they go to that street, and we will be able to close all the loopholes and put them where they belong, in jail. So even getting their property back, we will do so. Precisely all those things that you articulated. You should be working for government. Thank you very much, Honourable Speaker.
The last supplementary question will be asked by the Honourable Radebe.
Thank you, Madam Deputy Speaker. Honourable President, recognizing the need to disrupt the leadership and organizational structures of these criminal syndicates, does your administration have plans in place to establish specialized multi-agency task forces combining the capabilities of SAPS, the SANDF, intelligence agencies to systematically infiltrate, dismantle, and prosecute criminal networks operating across provinces and borders? Thank you.
The Honourable President.
Thank you, Honourable Deputy Speaker. Honourable Radebe, the answer is yes. I've said very clearly to the police and the Minister of Police that let us focus, let us get specialized teams to focus on particular areas of criminality and be so specialized, because the criminals become specialized as they do their terrible deeds. We must be able to catch them even before they do those terrible deeds. Intelligence must work very, very, very intensively, and all the criminal justice entities. During COVID, we set up what we call the Fusion Center. The Fusion Center involved all these agencies, including the Financial Intelligence Center, the NPA, and many others. And they have continued to function as a team. We want them to strengthen their resolve so that we focus on gangs, we focus on illegal mining as they are, we also focus on murder and gender-based violence and all these acts of criminality. That is precisely what we are doing. We found that when police become specialized, when they become specialized in particular task teams, they become real experts because all their focus is on a particular area of criminality, and they get to know the actors very well as well. So the answer to your question is an overwhelming yes. We will continue doing so. Thank you, Honorable Deputy Speaker.
Honourable members, that concludes questions to the President. I thank the Honourable President.
Malibongwe.
Order, honourable members. I request members to stand and wait for the presiding officer and the mace to leave the chamber, and that concludes the business of the day, and the House is adjourned.
Diabulela, President. One love, one family.
One love, one family.
40 24-hour clinics for our clinic.